Folks, good afternoon. I call the Committee of the Whole on Bill 7 back to order. We are on Clause 10 as amended. Shall Clause 10 as amended pass? The Chair recognizes the member from Richmond-Queensborough.
First of all, I'd like to thank the Attorney General and Attorney General staff for answering questions so far. And so thank you for the question. Thank you for the answers to my questions so far. And just as a matter of recap, the last question that I was asking was in regards to the retroactivity provision here in Clause 10. So Clause 10 sub 2. So we were speaking of a directive issued on or about June 30, 2025 under this part may be retroactive to February 1st, 2025 or at a later date, and if made retroactive is deemed to have been issued on a specified date. And the last particular question we dealt with was we got a little bit of a timeline. A few dates were provided. We were looking at February 1st, February 3rd, and now. So first, this particular legislation addresses February 1st, and February 3rd was the date that some sort of declaration was made by the Premier in response to the executive order from the U.S., so that was February 3rd, and now we are into May. And so basically the question was, were any of these government procurement entities left exposed to liability as a result of any sort of actions that may have happened after the Premier's response statement? And so I believe the response there was that that's why we are dealing with this particular legislation, and that's where we kind of left off. And now I will continue with that line of questioning. So, and this has to do with time periods in regards to the procurement entities. Can the Attorney General confirm how many directives, formal or informal, were issued prior to February 1st? Were there any directives that were issued before February 1st?
Attorney General.
None, because this legislation, if you're talking about procurement directives in this legislation, then no, because it's not in place. You're talking about any other directives. As we mentioned last time, it was after the executive order of February 1st of the president that any actions were taken.
Member for Richmond-Queensborough.
I guess I should clarify what I was after was, I shouldn't have said directives, I should have said actions. Because what these government procurement entities may have done was take actions as a result of a response declaration. To the Attorney General's knowledge, did any of these government procurement entities take any sort of actions? And I believe the Attorney General referenced at the time who could have probably been government procurement entities, could have been some crown corporations. I believe that's what the Attorney General was explaining. So I want to know if any sort of actions were taken that were kind of related to this legislation in regards to U.S. tariffs before February 1st.
Attorney General.
Not that I'm aware of before February 1st.
Member for Richmond-Queensborough.
Follow-up question, between February 1st and February 3rd, were there any actions taken by any of these government procurement entities that the Attorney General was speaking of last time?
Attorney General.
So we talked last time about the directive on the 3rd that the Premier publicly talked about, or the direction on the 3rd. But I guess I would have no way of knowing if a government procurement entity or government reporting entity, as of February 1st, when the tariffs were announced, if they had a special meeting or a board meeting or talked about how they were going to look at their procurement policies. These are all things that are possible, and they wouldn't be something that I would know.
Member for Richmond Queensborough.
So the next time period is from February 3rd to now. Has there been any actions taken by these government procurement entities from February 3rd to now?
Attorney General.
So there's a few things going on in the period that the member has described. So the first thing I would say is that government and myself here have no way of knowing of all the government procurement entities that would be captured by this legislation, what actions they've taken from February 3rd till now. So that is an answer I can't give, nor would we know that. So, but we do know is that February 3rd, the Premier issued a procurement action, purchasing directive to talk about how Crown corporations should act or could act in response. But because of the start and stop nature of the tariffs from then on, there was if we all can cast our mind backwards to that time, there was the start, and then there was the pause till March 4th, and then there was a start again. So it was a bit of a off and on period with respect to that. The Premier's one that was on the purchasing directive. But what we don't, and again, I have no way of knowing for all government procurement entries from now, since February 3rd, what they did with their procurement.
Member for Richmond Queensborough.
Can the Attorney General tell us why there are no regulatory reports from any of these government procurement entities saying whether they took steps or actions pursuant to the Premier's statement in regards to these procurement entities?
Attorney General.
So we have to remember that this is an unprecedented approach that we're taking to unprecedented times. So try to align procurement policies in a particular way across all government procurement entities. So that's kind of never happened before. So then there would be no regulatory regime under that to require any reporting requirements. And there isn't one that existed before, but all procurements are posted on BC Bid. And so there is each entity would have their public reporting through that process.
Member for Richmond Queensborough.
Can the Attorney General list those directives that are available on BC Bid?
Attorney General.
Yeah, let me clarify. I didn't mean procurement directives because the legislative tool for a procurement directive is not in place. It's in this bill, and if it had to be in place, what I'm saying is what was happening before this unprecedented effort to align procurement somehow is entities doing their own procurement. And when you do a procurement, the policy is to go through BC Bid. That's the place of it. So that's how they would show it to the public.
Member for Richmond Queensborough.
So can the Attorney General provide the list of what the procurement entities have been doing according to BC Bid?
Attorney General.
That would all be on BC Bid. It's public. The member can take a look at that and between those dates.
Member for Richmond Queensborough.
Okay, and the Attorney General mentioned this is unprecedented times in terms of dealing with directives and dealing with government procurement entities. But we're specifically dealing with the proactive clause, subsection 2. And I believe the Attorney General stated that there's precedent for proactivity or retroactivity. And based upon that, there should be some sort of examples of where retroactivity has applied. So, yes, so does that not help the Attorney General in terms of answering this particular question?
Attorney General.
I think we're going to need some clarification before we answer that question. I believe we were talking about before when I mentioned that there's retroactivity provisions in other pieces of legislation. So to have retroactivity apply by a clause is a common thing in legislation. And that's what I was referring to when I was talking about that provision. So maybe some clarity in the question would help me answer.
Member for Richmond Queensborough.
I believe the question had to do with regulatory bodies reporting what they're doing, and we're also talking about retroactivity. We're trying to get a clarification. I was told that retroactivity provisions exist in other legislation, and I assume there should probably be some sort of regulatory reporting in those other regimes. So applying those examples, those precedents to this situation, I'd like a further clarification from the Attorney General in regards to my previous question.
Attorney General.
Okay, so there would be no reporting requirements because the bill is not law of the land. So this particular retroactivity clause or the powers of procurement directive are not enforced right now. And as I mentioned earlier, there is no regulatory regime for procurement reporting requirements of government procurement entities because there's never been a desire or a move to try to align it and have the powers of cabinet to do such things with procurement directives in the province. Now, the member asked about other retroactivity clauses and reporting requirements. It's actually impossible to compare because retroactivity could show up in many different ways in many different legal regimes, in many ways in which reporting would make sense to put that in there, and I would say unhelpful to the context of this section.
Member for Richmond Queensborough.
So we were asking specifically about the retroactivity provision that we're looking at, and then we got and then we were asking about reporting actions by these these procurement entities, and in specific to the actions that they may be taking. So I understand we have unprecedented time, but throughout parts of this discussion that we've had through Clause 10, we've also been told that there's certain precedents to have like retroactivity, and I understand that there won't be an exact situation to resemble this, but the government has looked at certain precedents in the past. So I'm just wondering that the other thing here is that there was a Premier's declaration stating that certain what they would do with certain procurement entities here. And it's my understanding that some procurement entities are probably acting, or they can actually act pursuant to the Premier's orders based upon our previous debate. So so there may be certain actions being taken. So is there no framework right now to kind of find out what sort of actions they're taking other than the BC bid and what directives what has been bought and sold?
Attorney General.
Thanks. So we have to remember that this whole thing that's put in place is using existing reporting and accountability processes. So I'll take the member back to 7.5, where it talks about our accountability for procurement directives, that we would publish what the procurement directives are on a website. That goes then to direct the government procurement entities to direct their procurement in a way. And we have to remember also too that this is a way of making it clear and consistent throughout. So right now, each government procurement entity would have their own procurement processes, their own accountabilities, their own public reporting, sometimes through annual reports. But the ultimate public transparency and accountability is the BC bid process. So anything that's not a direct award, and you remember what we talked about earlier, that this doesn't cover direct awards under a certain amount, the government procurement entity goes through the BC bid process. And the BC bid process is a public and transparent, essentially a call out on the terms of what that procurement is. So it makes it very clear how they're acting on the procurement directive.
Member for Richmond Queensborough.
Is it fair to say that the Attorney General's office probably had a briefing of how these government procurement entities operate prior to this legislation being formalized?
Attorney General.
So no, I did not get a briefing on every government procurement entity's procurement processes. That would be a lot of time and probably unnecessary definitely unnecessary because I have a team that, as we talked about quite a bit during the conversation we've had about how this bill was made up, that has been deeply engaged in internal discussions, particularly about our processes and the experts within government and our legal experts that are before you here today. My job is to bring forward the enabling legislation, which is what we have before us today, to give the government the tools to do the work of issuing procurement directives in a clear, concise way.
Member for Richmond Queensborough.
So I just would like to clarify the Attorney General's position in regards to the Premier's response declaration. And in regards to that, government procurement entities, it was permissive for them to act on that Premier's response declaration, correct?
Attorney General.
Okay, so the February 3rd announcement that the Premier made was for, and it contained the word must, and it was related to exclude US. And it was focused on future procurements. And it was circled around Crown Corporation, so it was about 29 entities. It's not as broad as what this bill would cover.
Member for Richmond Queensborough.
So the Premier's response declaration, according to the Attorney General's interpretation, it wasn't just merely permissive in language, it was instructive in language, correct?
Attorney General.
That's right.
Member for Richmond Queensborough.
Were any of these foreseeable government procurement entities that were going to be affected by this declaration, did any of them receive legal advice prior to acting on the Premier's response declaration?
Attorney General.
So these are pretty sophisticated organizations. I know the member's a lawyer himself, is that we wouldn't necessarily know and they wouldn't disclose if they received legal advice or obtained legal advice or what that legal advice is, but they are Crown, in this instance, they were Crown corporations and including health authorities, so very sophisticated organizations.
I understand that the Attorney General's Department may not know what the legal departments of these particular government procurement entities may have said or may not have said. I understand that bit. Follow-up question to that is, did the Attorney General's Department or did the government give any legal advice to these government procurement entities in terms of what rights and obligations and consequences that may exist as a result of following the Premier's instructive instructions?
Attorney General.
So whether or not they have obtained legal advice from our lawyers is protected under solicitor-client privilege, and we can't disclose that. But again, I'll say that these are organizations that are very sophisticated and have their own team of lawyers.
Member for Richmond Queensborough.
These government procurement entities, now we're talking about this retroactivity clause right now. And what the government's trying to do with this retroactivity clause is try to give a blanket protection to these government procurement entities. So is it, and these government procurement entities may have taken actions because we just learned the declaration was instructive. The language must was used. Is it fair to say that these government procurement entities may be exposed to legal liability right now for certain actions they may have taken? And they may have exposed taxpayers to financial risk?
Thank you. We have canvassed this to quite some extent already, Chair, and I've said that this was a forward-looking procurement directive. It wasn't meant to breach contracts. There was a mitigation of any any risk of liability at the outset. And then to follow up, I got asked directly whether or not I am aware or know of any legal liability incurred by any of the government procurement entities, and I answered pretty directly no. So I believe this is asked and answered.
Member for Richmond Queensborough.
So as far as any lawsuits, is the Attorney General's office aware of any specific lawsuits have been filed since February 1st to now?
Attorney General.
No.
Just to switch the line of questioning here, next question I want to ask has to do with this particular retroactivity clause. And I would like to know from the Attorney General's perspective, is this going to set a precedent so that we will see further legislation that's kind of similar in scope, use these retroactivity clauses because we're using it here?
Attorney General.
So retroactivity is a pretty well-defined role it can occur and legislators can put in legislation. So it's not uncommon as a precedent. There are circumstances where it calls for it as a tool in legislation. And that could be depending on the circumstances and the unusual circumstances of whatever bill is before them. So in the context of the way that the well-developed legal principle of how retroactivity can apply or not apply through legislation, I would say that the floodgate argument that I think the member is suggesting might be available here is just not, because of the way the law is on retroactivity.
Member for Kelowna Mission.
Thank you very much, Madam Chair. Now, I'm not an international trade lawyer, but I hope that the Attorney General can help me understand. Can the AG confirm whether BC's obligations under the WTO Government Procurement Agreement apply to procurement processes affected by retroactive directives issued under Bill 7, including those dating back to February 1st, 2025?
Attorney General.
Yes, they do, because there's nothing about this bill or anything in what we were talking about that would say that we were getting out of our WTO obligations.
Thank you very much. And has the government received legal advice as to whether issuing procurement directives retroactive to February 1st, 2025 could place BC in breach of Canada's binding commitments under the WTO GPA, particularly the non-discrimination and transparency provisions?
Attorney General.
Yeah, thanks. So the question about whether I obtained legal advice, we're surrounded by lawyers here. So you're getting the bill was obviously constructed by trade lawyers and all of our team. So we talked about this way back about the unprecedented legal times that we're in right now. So under the context of trade agreements, we are a jurisdiction that abides by our trade obligations and that generally has signed many free trade agreements and is signatory to them. In the context of this trade war, where we have an actor that is breaching our trade agreements, including CUSMA and all the other things that we would be signatories, or the states would be signatories to, this is a specific action that's designed to target the bad actor. So the procurements are not about other jurisdictions that we may have signed trade agreements with, it's about exclude America. So that's how we've designed our legal response. And to show that we are upholding the rest of our obligations.
Kelowna Mission.
Thank you very much, and I appreciate the fulsome answer. Definitely understand where the AG is coming from. I'm just trying to understand some of the implications. Can the AG identify which BC ministries, crown corporations, or agencies are specifically covered under Canada's Annex II commitments in the WTO GPA, and whether those entities would be subject to any procurement restrictions imposed via Bill 7?
Attorney General.
Okay, so what the WTO covers is ministries, commissions, boards, agencies, committees of BC. So essentially, that's core government.
Kelowna Mission.
Thank you very much, Madam Chair, and thank you, the AG. What analysis has the government undertaken with regard to retroactive procurement directives disrupting tenders already initiated or contracts already awarded to U.S. suppliers prior to the passage of Bill 7? And what is the legal exposure in that situation?
Attorney General.
Thank you. Asked and answered, Chair. We talked about our perspective and how we've designed these to be forward-looking and not to breach contracts.
Thank you and appreciate it. Can the Minister clarify how Bill 7's retroactive procurement powers interact with the GPA thresholds for covered procurements, particularly those above the $350,000 Canadian threshold for goods and services, where Canada has pledged equal access to U.S. suppliers? Recognizing, of course, there is an effort to disrupt the status quo, I just want to understand what legal processes and remedies may be triggered.
Attorney General.
I might have to get some further clarification on the question. I'll just give the member what we landed so far, which is that under the GPA, it's 627,000. That is the limit. If anything below that is not covered. So just to clarify the question. And then the other thing I would just add is that nothing in here interacts or we think does anything with the that GPA under the WTO. And so if there's a further question that's a follow-up, I might be able to get deeper into the conversation.
Kelowna Mission.
Thank you very much. And I appreciate the perspective. I am trying to just get an understanding as to the interaction with the GPA and what the implications are or could be. It's obviously not a simple area, but it has potential complexities and complications and consequences, particularly with regard to exposure for the taxpayer. So if a BC procurement directive under Bill 7 were to exclude or penalize American bidders after February 1st, 2025, would this be construed as a retaliatory trade measure? And if so, does the minister believe BC has constitutional authority to implement such a measure independently of the federal government?
Attorney General.
Okay, so good question. And the way that, okay, let me break down the answer. So we have control over how we spend our money. So how the government directs its money and expenditure and makes contracts is within the provincial control. But you have to remember, we are working in a Team Canada approach. When we were at the table with every premier and Prime Minister to coordinate our responses. So in terms of retaliation or retaliatory tariffs are very much the things that are within the Canadian government's response and control. And this one would be in ours, and it helps us direct our spending in a way that is within our ability and powers.
Kelowna Mission.
Thank you, Madam Chair, and thank you to the AG for the answer. And certainly appreciate that coordinated approach and that conversation. That's obviously very important. To that end, what mechanisms are in place to monitor and ensure compliance with GPA obligations when issuing procurement directives under Bill 7, particularly given the complex political environment and the challenges of coordinating with a federal government under new leadership that is in itself in flux?
Attorney General.
Okay, thanks. So when the process of the procurement direction is put in place, there'll be an order in council that's public, and at that point is the opportunity for the legal advice, legal analysis that the member was asking about related to other obligations or how we're lining up the procurement. And then once they're issued, each of the entities would have internal legal advice or internal advisors that would help to advise them on like the specific procurement or question related to their entity.
Kelowna Mission.
Thank you very much. Certainly recognize that that will be relevant on a direction-by-direction basis. But just to make sure that I understand the situation currently, has proactive work been done and are guidelines or initial thoughts in place or initial analysis in place with regard to ensuring compliance with GPA obligations, or at least ensuring a strategic approach to GPA obligations?
Attorney General.
Yes, yeah, definitely, and it would be part of each procurement that was initiated. And I would say that to the credit of the trade lawyers that are listening right now attentively, they have been very keenly and very aptly advising every ministry in a rapid basis in an uncertain territory. So we are grateful for the work that they're doing. And in that work is a detailed analysis of all of our obligations and how they show up on a particular issue, and we're grateful for their work.
Kelowna Mission.
Thank you very much. I would also just take this moment to echo the Attorney General's thanks to all the many lawyers that have been working on this file. We know this has been a long and arduous process. We recognize the complexity of the work you're doing, and we really do truly appreciate all of that. For many of the other folks, the many thousands who are watching this at home, they may be bored by this section, but I know that this is absolutely scintillating for the trade lawyers watching. And I see the smile on the Attorney General's face as she also appears to be enjoying this phase of the discussion. Has the Attorney General or the Ministry of Jobs, Economic Development and Innovation assessed the long-term chilling effect of American firms bidding on BC procurements and the risk of reciprocal discrimination against BC suppliers in U.S. state-led procurement markets? And in particular, has there been analysis undertaken on the proportionality of the size of those markets and the implications in terms of sales into those markets, so that we can understand just what in the long term the scarring effect of this dispute may be, and again, what the scale could be?
Attorney General.
Yes, so the member correctly notes the very complicated environment we're in when it comes to a trade war and the escalation, and that we are going to be firmly situated in the support of BC businesses and the Canadian economy. So we believe that the tools in this bill will help us do that, because it's got the flexibility that you would need to design a procurement directive with the right amount of proportionality that would take into account how you will address that very nuanced and sometimes very complicated, probably per sector to analysis, that as some of the concerns a member has raised.
Kelowna Mission.
Thank you very much. With the preface that, of course, we are in a dispute. Disputes will escalate. We recognize that there is a dispute bigger than the mechanics of individual parts of the trade infrastructure. Nonetheless, I do want to understand, given that procurement obligations under the WTO GPA operate independently of CUSMA, does the Minister acknowledge that Bill 7 could trigger a WTO procurement dispute even if no formal action is taken under CUSMA?
Attorney General.
So we're existing right now in a very complicated international trade environment, and there are already claims at the WTO related to the actions of the president, and I think there are also questions about whether the WTO is fully functional at this stage and its ability to resolve these disputes, but that's another discussion. But I think that what we've designed here with procurement directive gives us the flexibility to just target it to minimize trade disputes and and be more directive about how we want to approach our response in this changing environment. And the power of it being a regulatory instrument is that we can also adapt it pretty quickly. So just recently, we were just discussing about the film tariff announcement that we don't know if it'll happen or not, but let's hope it doesn't. But if it actually does, then you can see how you can change your directives in response to what's happening, but then the context of minimizing escalation, or maybe you want to escalate. Like there's an ability of government to respond in different ways.
Kelowna Mission.
Thank you very much, and I appreciate the AG's clarity around escalation, the intent to escalate, the understanding of, if you will, expected and deliberate violations versus unintended violations of various different rules. I think that's a very important distinction to make, and it certainly is much appreciated. And with that in mind, what safeguards or internal legal review processes are in place to ensure that procurement directives issued under Bill 7, whether retroactive or prospective, do not give rise to unanticipated or non-deliberate complaints or litigation under international trade agreements?
Attorney General.
So as mentioned, with the team that we have here and our good relationships with all the government reporting entities, that at the time of development of the OIC would be the time of doing that particular legal analysis.
Kelowna Mission.
Thank you, very much appreciated. And that makes a lot of sense. Just as it relates, I think in previous discussion of the bill, we've canvassed the directions and the execution of directives, and we've talked about the hypothetical zealous staffer executing a directive, following direction, executing beyond the intended or strategic scope of the directive provided, potentially escalating beyond the intended escalation that was intended by the direction. Taking into account what the Attorney General has just said around those formal processes, I do just want to understand the belts and suspenders approach around how we're ensuring that individuals who may not be legally fluent, who may be understanding a directive secondhand or thirdhand, do not inadvertently create escalation or create unintended consequences with the way that directives are implemented on the front line.
Attorney General.
I will indulge an answer, even though I think I've answered this already. So the first thing that I think we talked about in clause 8 and 9 is through our immunity and indemnity provisions, we are setting a standard of conduct. So if you want to be protected by those provisions, you have to operate by a certain standard. So already that is us signaling to all of the government procurement entities what we expect of them. But I think also we need to remember that these are sophisticated organizations that are already operating under very complicated regulatory frameworks. And we're talking about procurements that are relatively large, right? So they're above a certain amount for a direct order. I think it's 75,000, or I can get that number. But these are sophisticated organizations that are able to operate at that higher level of procurement. So I would expect that, and I know that they have the internal mechanisms in place and the right kind of advice in place to implement these procurement directives. And also, there's a level of just transparency in the standard and how we want them to conduct themselves, just in the fact that once you have an OIC or procurement directives, it'll be public very quickly about what that is saying to that entity.
Kelowna Mission.
Thank you. That's very helpful. I don't think I'm asking a repetitive question, and I am trying to understand in good faith where this is going. I certainly recognize that as it relates to directives, as it relates to the high-level direction provided to government procurement entities at a corporate level, I take at face value what the Attorney General says around that sophistication and whatnot. But what I'm hoping to understand is what the war room, what the rapid response component looks like when we start potentially dealing with situations where the implementation of directives, where that rubber actually hits the road, because it is my experience in dealing with comparable situations in large organizations that it is rarely in the general counsel's office of a major entity that someone steps on a rake. It's usually a lot closer to the pointy end of the stick. It's a lot closer to the implementation, and there may be line managers, there may be individuals who are not in regular conversation around the strategic intent or the legal construct of some of these directives. So they might be an individual procurement manager managing a scope of procurement that is much closer to the bottom of the end of the procurement size versus these major pieces of procurement. So is there some kind of a centralized training or support structure or rapid response functionality being put into place in order to ensure that errors in administration are addressed quickly? I recognize that we have canvassed extensively the various legal protections available, and we don't need to go back to that. But what I want to understand is the effort being made to avoid ever getting into that legal hot water where those kinds of protections are necessary. So how we are resourcing, supporting, training, providing some wraparound for the folks in charge of operationally administering these procurement directives at the front lines versus just for the procurement entities themselves.
Attorney General.
So in these very sophisticated relationships and organizations, there's a multitude of safeguards in place to prevent what the situation the member is talking about. So I would start by saying, first of all, that the relationship is pretty strong between government and the government reporting entities, and there's an institutional structure that is kind of like their resource if they have any questions. It's the Crown Agency Secretariat. CAS, and that is staffed up from people that are there to provide information to these entities. And I know that internally there's every procurement entity or group in an organization has to have yearly courses on how procurement unfolds and what the correct procedures and processes are. So these are all resources that are available and would be available to the government reporting entities. And then I also expect that they have their own internal structures that would be about employee training, hierarchy, accountability, how they report their procurement, all those things that are safeguards in place to prevent that.
Kelowna Mission.
Thank you very much, and much appreciated to the Attorney General. As it relates to the governance side of those GPEs in the case of those that have governance boards, just since we're on the topic, can the AG tell us a little bit more about how, whether through Cabro or anywhere else, how board members of relevant GPEs have been equipped to deal with complexities emerging from this situation? Is training being provided to board members, or have there been any changes where, for example, for major entities, new board members may have been appointed or are considering being appointed who have governance level experience in dealing with international trade or with these kinds of complex procurement matters?
Attorney General.
Thank you. So it's called Cabro now, so thank you. CAS? It's called CAS now. It's called CAS now. I didn't know that. Okay, well, okay, called CAS. So they have, under there, they do have a lot of training and advice, but there also is a merit-based process that usually happens for them to figure out what they're missing on their board. So they do their matrix and then fill in gaps. But I think the member raises a good point in the context of like when you're responding to ever-changing times, that you would think that now one of the assessments that they would think is how to operate in the context of a trade war, like what other skill sets they may be needed in their particular sector or industry that are related to the times that we're in. So unfortunately, I guess I'm sure that'll be part of the thinking going forward.
Kelowna Mission.
Thank you. I was impressed with myself that I got it right. I didn't call it Bordeaux, I called it Cabro, but now it's CAS. I mean, it's hard to keep track of the acronyms. I do have some familiarity with the skills matrix used for those boards, having previously served on one of them, and I did find it to be an excellent process. I thought very good work was done to make sure that we were filling all those skill areas. I think the AG raises a depressing but good point about the need to ensure that we have that kind of a skill set covered off going forward. I just to stay on that point for 1 second, if you'll indulge me, I'd like to understand whether, again, there have been specific changes made to board resourcing in the last several months. For example, are there major boards that are particularly affected by this situation where there have been significant injections of new board talent, new people stepping onto boards in order to make sure that we are as prepared as possible to deal with this situation?
Attorney General.
So we have not seen that at this stage, but I think, we'll see if that does happen. And I think right now, CAS has the resources it needs to respond to what's needed out there.
Councilor Mission.
Thank you very much. Appreciate that. So just to return for a little bit to the implications of the WTO GPA, can the minister explain whether the issuance of a retroactive procurement directive under Bill 7, particularly one that changes eligibility or evaluation criteria after a tender has closed, would violate the GPA's Article X5 requirement that the conditions for participation shall be published in advance? So those would be instances of midstream procurement, for example, that might be proceeding down the track from, say, RFPQ to RFP or wherever else in the procurement process.
Attorney General.
Thanks. So we wouldn't be asking, for many reasons, for things to end mid-procurement or the time of procurement that the member asked. This is a go-forward basis. It's looking forward, and it means precisely for the reasons that we, probably the members raising those concerns, is that we know that there's contractual legal obligations that are started at different stages of procurement. We're talking about designing procurement going forward.
Councilor Mission.
Thank you. I think that's very helpful, and it does raise an interesting point. What is the value in dollar terms of procurement that was considered by government to be midstream at the cutoff point where it was determined that procurement processes underway would not be affected by changes?
Attorney General.
Thanks. I don't have that number, and I don't know that it's relevant to this particular clause, but I would ask the member to maybe reach out to Citizen Services to see if they track that kind of data.
Thank you very much. Yeah, the intent of my question is just to understand, I'm not sure what the right term would be, but what the volume of kind of orphaned procurement or midstream procurement would be. Just recognizing that on the one hand, I would respectfully submit or just ask to try to understand, we simultaneously have the bill creating the ability to undertake retroactive changes to procurement, and if I understand the Attorney General correctly, it appears that there's an understanding or a decision taken in government around some processes that are already underway being ring-fenced or deemed out of scope for those kinds of changes to be made. Could the Attorney General just expand a little bit on the process undertaken to determine which processes currently underway have been ring-fenced, what basis those decisions were made on? And it would be helpful, recognizing that may not be in scope, to understand the scope of that. I think people have a reasonable expectation of understanding. Is there a whole bunch of procurement that is currently midstream that, again, is deemed to be out of scope? And if so, at what point do we actually realistically expect that any directives would be imposed? I think it's a very important nuance.
Attorney General.
Just to provide some clarity off the top that I think might help situate this clause a little more directly in its purpose. So the purpose of this clause, and I remember we talked a lot about indemnity and those provisions. So the purpose of this clause is to say to people that may have been operating under something that was like a purchasing directive and putting them under a more consistent procurement directive, that you could issue it to make it retroactive for those indemnity and immunity provisions to be there. It would not be there, and it would be written right in the directive, to say anything about breaking midstream procurements or procurements that are existing or in process. So when we're talking about retroactivity, it's not to reach back in time to procurements that may be underway and say change the midstream. It's to provide the indemnity and immunity protections for entities that may have been operating under a purchasing directive or something under that beforehand that looks, and we talked about this before, you can decide if you wanted to apply or not, because to some extent that you have to look at what they've been working on and saying, yeah, this looks a lot like what we've asked you to do or we think we were all doing together. And then you would apply that procurement directive retroactively to help get those protections in place. So just to clarify, that they would not be used nor directed to end any past procurements or midstream procurements.
Kelowna Mission.
Thank you, I appreciate that. Returning to with the preface I've previously given around the understanding that we may wish to escalate, we may wish to violate, we may wish to do all these various different things, it's still important to understand how this will operate in the context of the WTO GPA. So is the government prepared to defend a WTO procurement panel challenge if a retroactive directive under Bill 7 results in the disqualification of a U.S. supplier from a process they bid on in good faith, relying on the rules in place at the time of submission? And again, this may interact with what the AG has just been talking about, but I am just trying to get a really clear understanding of midstream changes and either the reality or perception that midstream changes may be triggered using the powers available under Bill 7.
Recognizing the minister.
So there's a couple reasons that scenario, I guess, wouldn't happen. So one is that if you remember, we talked about all the entities that are covered under the GPA. Essentially, it's core government and it's not the GREs, so they wouldn't be covered under that part of the WTO related to procurement, so the GPA agreement. So the other reason would be in the scenario that the member describes, if there's a compliant bid that's made by a U.S. Supplier, and in that scenario, we wouldn't ask, no procurement directive would ask a government procurement entity to break that or end that particular situation if it meets all the legal requirements necessary. So that's another reason why that scenario wouldn't come into play.
Recognizing the member for Kelowna Mission.
Thank you. I'm thankful to the AG for the clarification. Can the AG provide the legislature with a list of any GPA Article 16 exceptions or derogations the province is relying on to justify the retroactive application of procurement directives under Bill 7? and confirm whether Canada in turn has notified the WTO accordingly.
Recognizing the minister.
Okay, so in the scenario where there was a challenge, first of all, any challenge like that is nation state to nation state. So we would obviously work with Canada to align, and the first step would be to do a fact-specific analysis if there are any exemptions that are available to us or defenses related to our obligations. And although, you know, I can't speak for Canada, generally speaking on these kind of international trade agreements, we work together with them. So then we would assess whether or not in that fact-specific analysis, if there were any exemptions or defenses available.
Thank you, Minister. We will now take a 5-minute recess, reconvening at 4:45. I call the Committee of the Whole on Bill 7, Economic Stabilization Tariff Response Act, back to order. Shall Clause 10 as amended pass?
Aye.
Recognizing the member for Kelowna Mission.
Thank you, Madam Chair. Thank you to the Attorney General, and thank you to the many lawyers watching and figuring out why I never went to law school. 20 lawyers, there we go.
Is that a question?
No, I know why I never went to law school. Okay, in the event that a directive under Bill 7 is deemed inconsistent with GPA rules, can the minister confirm whether the province of BC would bear the legal and financial liability for damages, or whether that burden would fall to the federal government as the treaty signatory?
Recognizing the leader of the third party.
My understanding is we're on clause 10. Is that
So,
correct?
correct, and my apologies,
and
recognizing the House leader
yeah.
of the third party.
No,
And
that-
we're on
that-
Clause 10 as
This-
amended.
This question, doesn't it relate to the application of clause 9? It's the interpretation of clause 9. Clause 10 simply says a directive may be made retroactive. It doesn't speak to, the questions related to clause 10.2 would be, what is retroactivity and how does it work? Clause 9 is the operation of the indemnification clause. My colleague, if had this question, my point for your consideration is that should have been raised under clause 9.
Thank you very much to the House leader of the third party. We have been providing a fair degree of latitude during the debate, but this is an important reminder that the question should pertain to the clause in question. Recognizing the member for Kelowna Mission.
Thank you, Madam Chair, and appreciating the observation by the member. In the event that a retroactive directive under Bill 7 is deemed inconsistent with GPA rules, can the minister confirm whether the province of British Columbia would bear the legal and financial liability for damages, or whether that burden would fall to the federal government as the treaty signatory?
Recognizing the minister.
Thanks. So there's no damages under the WTO. The remedy would be to remove the offending measures if it was deemed to be offending. But probably likely what would happen in a scenario like that is there would be some kind of cost-sharing agreement between Canada and the province. Obviously, you would know at the very beginning what you were facing, and it would be a fact-specific analysis that would undertake how the actions are, or what would be, what the approach would be between the province and Canada.
Recognizing the member for Kelowna Mission.
Thank you. Certainly an issue that is important for us that we have raised on a number of occasions is cost exposure. So since the Attorney General brings it up, could the AG expand a little bit on that cost-sharing mechanism and what, if any, principles or agreements or basis for cost-sharing has been established in the context of collaboration on a Team Canada basis?
Recognizing the minister.
So Canada, as a signatory to a treaty, would have standing under these trade agreements. So they have their own trade lawyers, and sometimes they would take on experts as needed. So right now, there is not a cost-sharing agreement, but generally, if there's experts that need to take on anything or other expenses, the cost-sharing agreement between Canada and the provinces would help cover that. And again, there'd be no damages, there's no monetary award, so this would just be for the cost of showing up in court.
Recognizing the member for Kelowna Mission.
Thank you, Madam Chair. Since the Attorney General raises it, can the AG expand a little bit on what, if any, discussions have happened with Canada and with other provinces around not just the sharing of costs, but an understanding of the sharing of impacts in instances where directives may provoke retaliatory measures affecting unrelated sectors, whether in BC or elsewhere, with knock-on effects into BC. I recognize we're straying a little bit from the core of our discussion, but it is a key issue that the Attorney General has raised.
Recognizing the minister.
So this is enabling legislation, as I think we've talked about before. So the time to do that would be the time at issuing a procurement directive. You'd be able to do that analysis of whether or not you need to include Canada and what kind of discussions you would have with them at that time.
Recognizing the House Leader of the third party.
Thank you, Madam Chair. Clause 10 sets out retroactivity of directives and through the chair to the Attorney General. I mean, this is going to be a fluid circumstance. That's why this is enabling legislation. This is why it allows the LG&C to give directives and make regulations that can then be amended as needed. Through the chair to the Attorney General, would it not be the case that prior to issuing a directive that involves the WTO or numerous other agreements that that legal advice would be sought by qualified lawyers, maybe not 20 lawyers, but maybe some qualified lawyers, to assess the implications and risks associated with taking the course of action that's involved in the particular regulation, and that if as a result of the regulation or some unforeseen instances by legal counsel advising on this, that there's a need for a change in the directive or an adjustment to the directive, that this legislation allows Cabinet to make those adjustments. Is that the case? Through the chair?
Recognizing the minister.
Thank you. Yes, it is the case. And we talked about the flexibility at the time of making the procurement directive to get that type of legal advice.
Recognizing the member for Kelowna Mission.
Thank you, Madam Chair, and I appreciate the point from the member. On this side of the House, we don't have the same access to the government that the third party has. So this is our opportunity to canvass these issues, and we do not have the privileges of access that the third party has in order to be able to receive ongoing efforts.
Member, do you?
I'm being impugned
Can
here.
excuse me, excuse me, I'm just going to recognize you as House Leader of the third party.
So I'm raising these issues in this forum. This is the appropriate place. This has nothing to do with privileged access. I actually find that somewhat concerning, but I just want to make it clear for the record that I'm raising these questions in this forum so that members of the public who are watching this and others can understand the extensive process that the Attorney General has confirmed is involved in making these sorts of important decisions. And I draw on that from my experience as being a lawyer for 25 years, working with First Nations and local governments and the BC, and dealing with the BC government, and prior to that, being involved in the drafting of legislation for the BC government when I worked for the BC government that was more complex than this legislation, where, yes, at that stage I was on the inside. But back to the more serious point, I don't have any privileged access. What I'm doing is raising a question, and the Attorney General's answered that.
Thank you very much, and a reminder to all members to please keep your questions to the clause in question, Clause 10 as amended.
Sorry, you got to recognize me.
Recognizing the member for Kelowna Mission.
Thank you very much. Certainly no intention to impugn in any way the member. I simply was observing that there is an agreement between the government and the third party which provides for a level of consultation and briefing around bills that is not available to the opposition. I simply was observing that this is the only forum in which we have the opportunity to ask these questions, and so we're doing so. So just returning to the substance of the bill and to those retroactive powers, has the government obtained legal clarity on whether Bill 7's retroactive powers violate the principle of legitimate expectations under international trade law, where suppliers are entitled to rely on the procurement rules in place at the time of tender?
Recognizing the minister.
So again, going back to the application of the GPA, it doesn't apply to government procurement entities, so we covered that off in our discussion. And then also, we talked about how the time to do the analysis for all of us is when you are issuing your procurement directive. So you're doing the legal analysis and trying to understand what you're going to put in the procurement directive and how it's going to apply.
Recognizing the member for Kelowna Mission.
Thank you, Madam Chair. And I think I know the answer to this one, but just for the purposes of clarity, can the minister confirm that all procurement directives issued under Bill 7, particularly those with retroactive application, will be publicly disclosed and registered in accordance with GPA Article 9 requirements on transparency and publication? I believe that that is likely the case based on my understanding of the bill, but I would just like to ask the Attorney General to confirm that for my understanding.
Recognizing the minister.
Thank you. So we took a look at that section in the GPA, and what it requires is for tenders to be public, so that that's fulfilled by BC bid. And then just to go back to the procurement directive aspect of this, that is public under section 7.5.
Recognizing the member for Kelowna Mission.
Thank you. That's as I expected. Thank you. Given that the WTO GPA requires that procurement decisions be challengeable through impartial and timely review mechanisms, what recourse will affected suppliers have if they are harmed or believe they have been harmed by a retroactive directive? And has the government consulted the procurement ombudsperson or established an independent review body?
Recognizing the minister.
So the courts of plenary jurisdiction, like the Supreme Court of British Columbia, would be where I would expect any of those claims to show up.
Recognizing the member for Kelowna Mission.
Thank you very much. And getting into the weeds a little bit here, but we're going to provide an opportunity for the 20 lawyers watching this to earn their keep. Has the minister received or reviewed any analysis as to whether a U.S. firm disqualified by a retroactive directive or believing themselves to have been harmed by a retroactive directive could potentially successfully pursue investor-state arbitration against Canada under Chapter 14 of CUSMA, alleging unfair or discriminatory treatment?
Recognizing the minister.
So I go back to my answer before. The time that you would be able to do this analysis to understand the risks and mitigate them would be at the time of making procurement, the procurement directive, and that would be a cabinet discussion.
Recognizing the member for Kelowna Mission.
Thank you very much. I'm struck by the fact that I respect that the answer in many cases may be that will be an analysis undertaken at the time of the issuance of a directive, but I would just like to understand whether these kinds of potential implications, intended or unintended, have been the subject of discussions in the development of the bill or have been identified in a risk matrix adjacent to the bill in order to understand what the full range of potential challenges or escalations could well be. So recognizing, again, that the detailed analysis of these implications may well be undertaken at the time of issuance, can the AG just confirm that there is some form of risk register or options analysis or other form of preparation that has been undertaken in anticipation of the emergence of these kinds of challenges at such time as directives are issued?
Recognizing the minister.
Yes, and I believe I talked about the assessments that would take place at the time of the procurement directive.
Recognizing the member.
Thank you, and much appreciated. And hopefully my last question for a while, he says, as the Attorney General smiles. Can the can the AG confirm whether BC is coordinating its procurement response with Global Affairs Canada and the Federal Trade Law Bureau to avoid unilateral actions that may compromise Canada's standing in multilateral trade negotiations or GPA compliance reviews? So again, just trying to make sure that the appropriate due diligence is being undertaken to ensure that, recognizing, of course, we are in this escalation with our neighbors to the south, there are also a whole bunch of other implications, both legal and relational, with other entities that are party to multilateral trade negotiations and multilateral trade agreements. So if the AG can just confirm that there are robust conversations underway about mitigating any unintended downside consequences in those multilateral agreements and negotiations.
Yes, so there are many levels of discussions happening related to our response, and we have a good relationship with Global Affairs Canada through many ministries, and we're always keeping in touch about responses.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair, and I promise I only have a few quick questions here. So, but I did want to follow up on. We've gone through quite a few questions from the member from Kelowna Mission on the international in nature. But before we got there, the critic for Attorney General next to me did raise some discussion about contracts and breach of contracts. And I recall that I heard the Attorney General say that, of course, the legislation is not meant to breach contracts. But in the case that there are unintended breach of contract, I'm wondering how government, what mechanism they would have to just deal with that and fix that issue if it did exist.
Recognizing the minister.
So I think that takes us back to Section 8 or Clause 8 and 9, and when we talk about the assurance that we give our government procurement entities under these procurement directives that if they're intending to comply with the directive, so if it was an inadvertent mistake or something that happened that incurred liability, that we would step in to protect them.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And I guess part of the reason I'm asking is I'm trying to help give more guidance for a delegated person to, I guess, know what happens in the case of an unintended consequence. Okay, I understand that we'll go back to 8 and 9 for that, so I appreciate that. But in terms of directives under Clause 10 and overall within Part 2, I'm wondering if those would be tracked separately, since some of those directives may be broader in scope than normal procurement practices. So will they be tracked for way of this bill separately than the normal tracking of procurement? So for example, when something goes through BC bid and goes through that process, will there be any mechanism where it's tracked separately for a procurement directive that is ordered in this case?
Recognizing the minister.
Yeah, thanks. So, yeah, there would be mechanisms in place to do that, because I think it would be interesting to see once, like BC bid, we talked about that being that public procurement process. So you'll know you'll know which ones are going in through a procurement directive or not based on the content of whatever's posted and all the internal mechanisms that we talked about over the many weeks we've been, and I guess the few days we've been talking about procurement directives, about how they're being issued or done under the procurement entities. So there would be lots of opportunities to collect data probably at that stage to understand how it's going, and probably some of those would be internal with the, so did they get the bids, where were the bids from, like how did it show up differently than when it wasn't in the procurement directive, so we can measure like how did they actually work in practice.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And I do think that data will be important to understand. I do think collecting that is very important. And I do think just for, by way of this bill overall, just tracking that separately and making sure that that data in the context of a directive that is ordered from as a result of this legislation, I do think it is important to understand the impacts after the fact. So I'm wondering in that same vein if the government would commit to a separate tracking of Bill 7 procurement directives in the public accounts, for example, or in another publicly available reporting mechanism.
Recognizing the minister.
Yeah, I know. I think the member raises a good point that we will have to develop those implementation guidelines, and I would be happy to engage with ministers that would be taking on these procurement directives to understand how we're collecting and tracking that. So I think it's something I'll definitely take away if this bill comes into force.
Recognizing the member for Richmond Queensborough.
Thank you, Chair. I have a interpretation question for the Attorney General on Clause 10, subsection 2. The clause states, a directive issued on or before June 30, 2025 under this part may be made retroactive to February 1st, 2025 or a later date. So the question is, why not just leave it at February 1st, 2025? And that would be all inclusive of anything all the way up to February 1st. Why write in a later date?
Recognizing the minister.
Yeah, so the wording is arrived at for a few reasons and why it's read like that. So first of all, you want to have the ultimate confines of a time limit for retroactivity, and anytime you use that power of retroactivity, it has to be clear and direct of how you're using it, and so you're not overstepping what we would think would be an extraordinary kind of or an unusual thing to do. So that would be one answer. And the reason that it says or later date is because you could say maybe made retroactive February 1st, so that's your one option, or a later date, so a date later than February. So you could say, depending on which entity you're looking at or which purchasing directive they issued before this was in force, and you could say, well, we're going to make this retroactive till, I don't know, it's like April 1st, right? So you've picked a later date than February. Because of the fact-specific analysis that you've done on that particular entity or sector on when you want to make that retroactive to. So it just gives that flexibility, but it also makes it clearer about the confines of the use of that.
Pardon me, sorry, my mic wasn't on. Recognizing the member for Richmond Queensborough.
So is the Attorney General saying if there wasn't any flexibility and it just referred to February 1st, 2025, some of the directives that would have been done after February 1st would not be included in this legislation? Is that what the Attorney General is saying?
Recognizing the minister.
Yeah, the reason for that or a later date in there is to give clarity that you can choose another date other than February 1st, just to make it clear if you want to go up to February 1st with your retroactivity, or if you want to make a section of that time.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And I realize we've spent a considerable amount of time on the last number of sections overall in Part 2 of the bill on procurement directives. Considerable amount on clauses 7, 8, 9, and 10, where we're at right now, talking about really how these directives will be delegated and how they will be implemented. But overall, this is a part of the bill that, and a clause that I'm just noting for the record that the opposition will have to be voting against for many of the reasons that we have been speaking about. First of all, the fact that we still have concerns that the directives may be arbitrary in nature. And with that brings a lack of business confidence and a challenge with that for the business community. We've talked at length about small and medium-sized businesses have already reached out and voiced their concerns, as have the largest businesses in the province through the Business Council of British Columbia. So we also have, of course, overall with the bill, a lack of transparency that we are concerned with, and that's been a considerable part of the opposition's questioning and discussions thus far of the bill, and this clause in particular. And by and large, though, we still have concerns that the government is trying to pick winners and losers in this case in procurement. So that's something that we are prepared to go to the vote on Clause 10, but at this time I have no question, but I wanted to note that for the record. Thank you, Madam Chair.
Thank you. Noting no further questions, shall Clause 10 as amended pass?
Aye.
Division has been called. Members, is there agreement to waive the remaining time as everybody is now present?
Okay, so then you gotta hit this bell. Want to do it again?
Before putting the question, I remind all members that only members of Section C or their duly appointed substitutes are authorized to vote. The question is, shall Clause 10 as amended pass? Those in favor, please rise or otherwise indicate. Thank you, members. Please be seated. Those voting nay, please rise or otherwise indicate. You may be seated. Clerk?
Aye. Sharma, Rutledge, Wickens, Davidson, Green, Dix, Botterill, 7. Those voting nay, Wilson, Payton, Neufeld, McCall, Maws, 5.
Clause 10, as amended, is carried. We now move on to the next clause. Shall Clause 11 pass? Oh, we have, I'd like to recognize the member for Richmond, Queensborough.
No, it's, I've learned that the Attorney General wants to vote against Clause 11, but I have some questions about Clause 11 because why was it there in the first place? So Clause 11 allows so I just want a confirmation from the Attorney General. As this clause stands right now, Clause 11 allows the Cabinet to unilaterally redefine who is a government procurement entity. Correct?
Members, we will pause for a 5-minute recess, reconvening at 5:36, please. I call the Committee of the Whole on Bill 7, Economic Stabilization Tariff Response Act, back to order. We are on Clause 11, and I'm going to hand it over to the Minister.
Thank you, Chair. So I can just explain the reason for what we'll be doing is moving to delete Clause 11. So the reason behind that is tied into Clause 6. So Clause 6, previously before amended, included a subsection B that said that a procurement entity could meet a corporation or organization is included in this definition by regulation under Section 11. And because that was deleted to provide clarity that a government procurement entity means a government organization is defined in the Budget Transparency and Accountability Act, there's no longer a need for Clause 11, which is a regulatory making power that is attached to nothing. So that's why we're seeking to remove it.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair, and appreciate the Attorney General providing that update. And this is something I learned in the course of debate earlier in our discussions, that this BC Chamber had raised some concerns. I hadn't actually spoke with them about this clause specifically, learned about that from the Attorney General, but I'm wondering if the Attorney General can describe what the BC Chamber's concerns actually were.
Recognizing the Minister.
Yeah, so the concerns when we were talking about this bill with many organizations, I think one in particular was related to certainty. So what could a government procurement entity be? So we amended the definition to make it clear what they could be, and then we no longer needed Clause 11.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And so can the Attorney General just provide an update whether any response that was received after the fact from BC Chamber, and if they had any follow-up questions, or were they satisfied?
Recognizing the Minister.
So BC Chamber's on the test committee. So I visited that committee and presented before the changes were made to Bill 7 and after. And provided an opportunity for any feedback or questions for any member of the test committee, and I didn't hear anything particularly about this.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And so just to clarify, no other comments on Clause 11 specifically, I guess, there?
Recognizing the Minister.
No, not that I've heard.
We just heard some concerns that were raised by some stakeholders, and and subsequently the clause efforts to now modify this clause exist, and but going back to my question that I asked first, it did allow. Clause 11 does allow, as it stands right now, for Cabinet to unilaterally redefine a government procurement entity. And this would essentially allow Cabinet to expand or exempt organizations at will, correct? Government organizations.
Recognizing the House Leader for the third party.
This is moot. This whole issue is moot. The earlier clause has been amended to remove any reference to Section 11 in this legislation. So there's no reason to be exploring the rationale and the context and the theories behind Section 11 because it's moot.
Are there any further questions? Recognizing the member for Richmond, Queensborough.
With all due respect to the House Leader of the third party, it is very important for the opposition to understand the intent behind why this was taken away, because in the public eye, there was a lot of opposition to this bill. And in order to understand, it's absolutely crucial to understand why this particular section is being taken out, so we have context for looking at future sections that are going to be coming up. And there, in the subsequent sections, we may not have the example that we currently have to kind of understand those following sections, and we will not be able to come back to this section once we move on. So it's absolutely crucial that we understand the intent behind it.
Recognizing the minister.
Thank you, Chair. Asked and answered. I went through the intent and I went through the reason for the removal.
Recognizing the member for Richmond, Queensborough.
So was there any other opposition other than that was explained by that stakeholder?
Recognizing the minister.
No.
Recognizing the member for Richmond, Queensborough.
Who directed the inclusion of this particular clause?
Recognizing the House Leader of the third party.
I'm just looking for a ruling on my earlier point of order that this discussion is moot, and this additional question about who drafted a particular section, I mean, that's moot too. This clause has no function in this legislation now.
Recognizing the member for Prince George Mackenzie.
Madam Chair, respectfully, the clause has not actually been amended at this point yet, so the opposition is still speaking to the clause without any amendments. So there are options. The government could either present amendment or vote it down, but this is the opportunity, as the critic for Attorney General said, to explore the intent so that it's understood why it's out and why it was included in the first place, and what in effect it does to the overall part of the bill.
Be- Because Clause 11 is in the bill, I will allow these questions. Recognizing the member for Richmond, Queensborough.
So the question that was posed earlier is in regards to Clause 11 as it stands. And so we've kind of learned that this clause, there will be amendment introduced shortly. But in regards to this clause as it stands right now, and because there's some intention from the government side to kind of remove it, that takes us to the question, why was this particular clause included in the first place? What was the government thinking when they were including this particular clause?
Chair asked and answered. I referred to Clause 6.
Recognizing the member for Richmond, Queensborough.
Who particularly reviewed this clause when it was being drafted?
Recognizing the minister.
So it would have been the drafting team, and the reason for the inclusion there would have been exactly what I talked about before, which was section 6B, which is soon being amended, has been deleted, required a regulation power under section 11, which is why this clause is no longer needed.
Recognizing the member for Richmond, Queensborough.
So would the Attorney General agree with me, this is legislative drafting oversight?
Recognizing the minister.
Not at all, Chair. This was not an oversight. I brought forward an amendment to Clause 6, and as a result of that amendment, deleted a subsection that referred to Clause 11 that is now, as the House Leader of the third party mentioned, is completely moot, and that's why it's being removed.
Recognizing the member for Richmond, Queensborough.
But the Attorney General would agree with me that the changes that were brought earlier on, they could have been brought at the time that this legislation was being drafted, correct?
Recognizing the minister.
Chair, we're in a circular discussion here. We talked many times, even when I tabled all of the amendments, that this was a process of government listening and understanding from different stakeholders what their input is on this very fast-moving bill in the context of the trade war. So I won't repeat myself.
Recognizing there are no further questions, shall Clause 11 pass?
Nay.
Clause 11 is defeated. Moving on to clause number 12 and recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And 2 clauses down. This has got to be a record for us folks. And at this point, yeah, we're.
The 3 will be the record.
To go in the day.
So moving along here, I do want to just take another opportunity to thank the staff from the Attorney General Ministry for being here. I know this is time out of your regular work, so we sincerely appreciate the work you're doing on behalf of British Columbians and supporting the answering of the opposition's questions. So moving to Clause 12, just want to get clarification, if the Minister wouldn't mind. Through the chair, can the minister explain the rationale for what Clause 12 is trying to do? Why is it in the bill, and what specific problem or scenario is it really intended to address?
Recognizing the minister.
So this is just a part of the legislative framework that BC Hydro is under that requires this consequential amendment. And BC Hydro's enabling legislation has a unique provision that requires an act that is intended to apply to it to specifically be listed in their act. So if that makes sense, we have to list this piece of legislation in the BC Hydro Act in order for it to apply to the BC Hydro Act.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair, and appreciate that clarification, and asking a few questions just for the benefit of the Minister of Energy, who I think will be helped by the clarification. Through the chair, just to confirm, does Clause 12 change any of the current legal obligations or protections for BC Hydro under Section 32 of the Hydro and Power Authority Act?
No.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And was there any need for consultation with BC Hydro, and did they have any additional comments or concerns as this clause was being drafted?
Recognizing the minister.
No, this is more of a technicality, and we just, it's just known because of the construct of that piece of legislation, the Hydro and Power Authority Act, that this is a necessary thing if you want something to apply to that entity.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. And just to clarify, if there are any other statutes outside the Hydro and Power Authority Act that apply or no longer apply because of this clause, or is it just the reference that's being changed?
Recognizing the minister.
Yeah, it doesn't take anything away, it just makes sure that this piece of legislation would apply to that entity.
Recognizing the member.
Okay, I think I understand that, Madam Chair, thank you. Also just another due diligence question in that same kind of vein, I guess. Could the minister maybe, or the Attorney General rather, just describe if it changes any of BC Hydro's liability or obligations to employees, ratepayers, or any contractors that work for them?
No.
Recognizing the member.
Okay, along the same vein, Madam Chair, does this clause alter anything with BC Hydro's relationship with the BC Utilities Commission or any other regulatory body?
Recognizing the minister.
No.
Recognizing the member.
That's great. We're just burning through some really straightforward questions, and that's the intent here. So thanks very much to the Attorney General. Does this clause affect any ongoing litigation, arbitration, or contract enforcement involving BC Hydro? And the reason I say that, just there may be obviously language that refers to the act in question, and does any of that, how does that get clarified?
Recognizing the minister.
Yeah, so this is a very narrow amendment that all it does is apply Part 2 of this bill to the entity. So all the things that the members speaking about are not affected or impacted.
Thank you, Madam Chair. And I guess that kind of leads to the question on why the Hydro Act, as opposed to other statutes, had to be included. I'm, as the critic for labor, just wondering why WorkSafe or, ICBC, for example, were not included or needed for that, and why Hydro specifically, this act.
Yeah, so it's just a unique piece of legislation that has a specific requirement within it for this particular Crown corporation. So that's the reason we needed to include it.
George Mackenzie.
Thank you. So I assume there was a legal review done of all of these acts to make sure that there wasn't any other obligations, so nothing that would have been missed or any other. I'm just thinking of the House time of this having to come back after the fact to be, with some sort of a miscellaneous statutes kind of fix or something like that. So there has been done an extensive review of all Crown Corporation acts to make sure this doesn't need to be included.
Recognizing the minister.
Yes.
Will this clause change any of BC Hydro's reporting or disclosure obligations? And if so, what would that look like?
No.
Recognizing the member.
Okay, so moving just again into the legal interpretation of this, how does the government interpret the interaction between Clause 12 and subsection 32(1), which says BC Hydro is not bound by other provincial enactments unless explicitly stated.
Recognizing the minister.
The member just nailed it. That's exactly the provision that requires us to list and amend.
Recognizing the member.
Thank you, Madam Chair, and maybe there's hope for me to go to law school one day. But is there, finally, is there a risk of legal ambiguity or challenge resulting from how Clause 12 might modify or invoke that Section 32 that just talked about?
No.
Recognizing the member for Richmond, Queensborough.
Thank you to the Attorney General and the Attorney General staff for now answering questions on BC Hydro and the legislation that deals with it. And so my question in regards to this particular provision is, by adding this section to the Hydro and Power Authority Act, does the Minister or the Attorney General, can the Minister or Attorney General direct BC Hydro and its subsidiaries to not purchase electricity from a specific source?
Recognizing the minister.
Yeah, so this would allow Part 2 to apply to BC Hydro, so that means that a procurement directive under the Part 2 provisions it would be Cabinet that decides, so not the Attorney General, it would be Cabinet that decides to direct the procurement of BC Hydro in whatever manner that they procure.
Recognizing the member for Richmond, Queensborough.
Is there any way is this in any way limited to only foreign generated electricity? Example, electricity not produced within BC. Is this
Recognizing the minister.
So just to make it clear that all this section does, or this clause does, is make Part 2 apply to BC Hydro. All the principles that we talked about at length related to Clause 7, Clause 8, Clause 9, and the powers that are included in any of the procurement directives, the ability to attach a procurement directive, all apply. So nothing has changed or particular about BC Hydro except the necessity to name it in their legislation because of the way their legislation is made up. So the debate that we've had about why we included or didn't include certain things, how things are listed under Clause 7, what the powers are, what those powers could be used to employ, all apply to this. to BC Hydro. This just enables it to apply to BC Hydro as well.
Recognizing the member for Richmond Queensborough.
Thank you for that clarification. That's helpful. But I just have a few questions here. And the answer might be the same that a reference is given to me for the prior answers given to about the other government procurement entities. But I just want to go further because this next question has to do with contracts. And BC Hydro, we know, also has an office in the U.S. and so is actively doing some sort of work across border as well. So so with this provision here and the applicability of this bill on BC Hydro, could this apply to contracts to produce electricity that have already been signed to produce electricity inside BC?
Recognizing the minister.
Yes, another thing we've extensively canvassed, and I think the member even raised this discussion about power and crossing the border electricity squarely in Clause 7. So we've had that debate quite a bit already, and I've already answered also that we would not require the breaking of contracts. So that's a discussion we've also had already.
Seeing no further questions, shall Clause 12 pass? Aye. So ordered. Shall Clause 13 pass? Oh, we have a question from the member for Richmond Queensborough.
So we are moving to Part 3 now. That involves tolls, fees, and charges. And the first section we're dealing with has to do with definitions in this part. And so it states, Clause 13 states, in this part, provincial undertaking means the following. A provincial public undertaking as defined under the Transportation Act. B, a ferry to which the Coastal Ferry Act applies. C, ferry terminal properties as defined in Section 30 of the Coastal Ferry Act. So my first question in regards to this particular clause is, does the minister believe that, does the Attorney General believe that this is exhaustive enough definition? Because we're dealing with a definition here.
Recognizing the minister.
Yes, we do.
Member for Richmond Queensborough.
The second question I have is, can the minister provide an example why the inclusion of we have okay, so I'm just going to go into the wording, actual wording interpretation of this. So in this part, we have provincial undertaking means the following: a provincial public undertaking as defined under Transportation Act, a ferry to which the Coastal Ferry applies, a ferry terminal provides. So there's a fair bit of discussion about ferries. Why was there more of elaboration on ferries in this definition than anything else?
Recognizing the minister.
Okay, so this definition is as it is for a few reasons. So one is to make it as broad as possible to cover a range of things. When you have subsection A there, it borrows from the way that's defined in that act. So under Transportation Act, it could mean roads, and it includes inland ferries only under that piece of legislation. So hence you need subsection B and C to make it clear that it also coastal ferries are included.
Oh, my mic wasn't on, my apologies. Recognizing the member for Langley Abbotsford.
Thank you, Speaker. Being the transportation critic, I got a few questions regarding transportation here. Can the Attorney General confirm whether Part 3 enables tolls on ferry routes, terminals, or access infrastructure under the definition of provincial undertakings? Because the broad language in this bill gives Cabinet far too much power, latitude to quietly impose new charges on transportation-dependent regions.
Recognizing the minister.
Okay, thanks. So now that we've switched to part 3, I just wanted to set up the tools and powers. I think the member asked a very broad question, and it's a good opportunity to explain part 3 and all its mechanisms and how they relate together now that we're at this stage. So this is the part of the bill that we hope to never use, but was related to, in the context of an escalating trade war, what we may have to do, and in the Team Canada approach. And the Premier has publicly talked about our ability to put a toll or fee on trucks that are going from one part of the States to another, through to Alaska. And that ability to show that we're serious, that if you're going to hurt us, if you're going to hurt us through trade, if you're going to put our businesses at risk of bankruptcy, if you're going to hurt our people by taxing them, then we're going to do the same to you. So in this category of power that we hoped we never use, we designed it and put it together in a way to allow us to have the flexibility to respond and the nuances to be able to respond in an appropriate way that does not harm British Columbians. So that shows up in a few ways. I think the member asked about affecting transport to British Columbians, and I guess I'll just, as we talk through the different clauses in the bill, I think it'll become really clear about what the powers show and how those powers are designed to be flexible and precise enough to be used in a way that does not harm British Columbians or their transport routes. So the procedural protections in this are that it's a cabinet OIC that's public, and when we get to clause 18, we'll be able to talk through, I think, in detail how precise the regulation could be, down to which road and what exact portion, and you could also define the class of users, the operators, the vehicles under the provincial undertaking. So the minister really has the ability, would be a cabinet OIC that has the ability to make sure that it is used in a way that doesn't harm British Columbians.
Thank you. Before we proceed, I'd like to just remind people that we've allowed considerable latitude in debate, and we want to remind members to ensure that their questions are focused on the clause under consideration, which is now clause 13.
Yeah, thank you, Speaker. I would also like to know, was there any consultation done with carriers or industries that use the ferry system to deliver their goods? And was it just big carriers, or were smaller carriers that are just individual owner ops involved? And were industries that use the ferry system to transport goods from here, like we know we have a ferry system in Victoria, Port Angeles is on the other side. Was any consultation done with the businesses that require that service?
Recognizing the minister.
Thanks. So this is an enabling piece of legislation, and what it does is it sets out in a very transparent way through the legislative process what the powers are in order to implement this. So just like the procurement directive that we talked about, it's enabling Cabinet to make a decision, and to make a decision through the details of Clause 18 that is actually nuanced in how it's going to affect and where. So with that, the proper time for the consultation and discussion would be at that time of consideration of where and when that power, hopefully never, would be used but needs to be used.
Recognizing the member for Langley Abbotsford.
Thank you, Speaker. Can the Attorney General explain exactly which provincial undertakings are being scoped for these new tolls and fees? Will this apply to major commercial routes like Highway 1, Highway 5, Highway 97 that truckers use daily? If the intent is not to toll our critical freight corridors, why not include that exemption in the legislation?
Recognizing the minister.
Thank you. I hope that this discussion doesn't become a conversation outside of the scope of this, which is a response to a trade war and a response very directly to what we're facing in terms of like Trump and what our people are facing in the context of that escalating trade war. Just yesterday, the president announced 100% tariffs potentially on our film industry. So this is a serious matter, and it is not a mechanism to put tolls to harm British Columbians. And I hope that's not the level of debate that we have on this section of this bill. So the tools in this bill allow the minister, again, to have that nuanced approach of what kind of regulation and what exactly would be put in place. And during that assessment, you can decide, or through cabinet discussion, decide exactly how precise you would like that to be.
Recognizing the member for Richmond, Queensborough.
I want to thank the Attorney General for her response to kind of explain what the government intent was behind this legislation. But the way that this legislation is worded, it could, in addition to having an intent, it could also have effect. And that's our question, the effect of this legislation. Could that effect affect BC people as the way this legislation is written right now?
Before I hand it over to the minister, I'd again like to remind us that debate pertains to Clause 13 only at this point. Thank you, and acknowledging the minister who was standing.
Happy to take questions.
Recognizing the member for Richmond, Queensborough.
I can rephrase my question, so we can go back to Clause 13 and the wording. It refers to provincial undertaking, refers to ferries, and when you read these definitions, these are to be included in the subtitle. It states Part 3, tolls, fees, and charges. So general British Columbians can be very concerned just looking at this. It says tolls, fees, charges, and then Clause 13 says provincial undertaking, talks about ferries. People use ferries all the time in this province. So, and the Attorney General just gave an explanation. The intent is not to go after British Columbians. But I'm reading this, I don't see any carve-out here for British Columbians as an exception. Based on the plain reading, would it be fair to say there is no exception to exclude British Columbians from this legislation in Clause 13 in particular?
Recognizing the minister.
Again, this is enabling legislation, and I think the members inferring intent of cabinet to act against British Columbians, which obviously is not the case, and cabinet is entrusted with many things, and the first and foremost is to uphold the interests of British Columbians and their all their needs. So the point of the drafting of this is to make it broad enough in order for the reg-making powers in Clause 18 to be able to really define where you would want to put these in place or not.
Recognizing the member for Richmond, Queensborough.
The problem with Clause 13 being so broad is exactly that. It's broad. And when it's broad, it includes everyday British Columbians. It includes everybody in this room. So yes, there is a concern in regard to that. I understand maybe the government had some good intent behind it, but the way that this legislation is worded right now, there are some concerns because the legislation is broad. And so I will kind of continue that into, I assume that we're going to get into that in later sections as well. But I'll ask other questions on this particular clause. So we were just talking about BC, we were talking about ferries. How does the government reconcile the inclusion of BC ferries operations and terminals under this definition? It refers to ferries and it talks about provincial undertakings. So how does this government reconcile the inclusion of BC's ferries operations and terminals under this definition with the intended governance independence of BC ferries as established under the Coastal Ferry Act? So BC ferries are supposed to be independent, and a lot of time I think there was there was some questions in the media asking the government about BC ferries, and the response was, well, BC ferries handles its own operations to go there. So with this legislation, it brings the ferries underneath this definition of provincial undertaking that this legislation applies to. Once again, the question is, how does the government reconcile the inclusion of BC ferries operation and terminals under this definition with the intended governance independence of BC ferries as established under the Coastal Ferry Act?
Recognizing the minister.
Thanks. So they're, anything related to their independence and their ability to set policies, that this doesn't interfere with that. And I just wanted to note for the member that the terminals are actually a property of the province. So that's a different, under different ownership.
I thank the Attorney General for her clarification on who owns terminals. That will probably help to understand this part of the legislation. But it's my understanding that the ferry system, BC Ferries, does own some assets and does kind of operate a little bit of arm's length from the government. And although it may not own the terminals, and that's owned by the government according to the Attorney General, I will ask the following question. Can the Attorney General confirm whether Clause 13 is intended to enable expropriation, compulsory acquisition, or forced control of ferry terminals? Ferry terminals, the Attorney General already mentioned those, but forced control of ferry terminals or ferries operated by BC Ferries. So the question goes to control. Is the government planning to control certain segments of what BC Ferries actually controls?
Recognizing the minister.
The answer to that is no, and there's nothing in this definition about provincial undertaking that would assume or even be able to lead anybody to imply that there is a power in this definition that would allow that to happen.
We haven't got to subsequent sections yet, but there might be an opportunity to answer this next question there. But since we're here, my understanding is that there's a little bit of latitude allowed in the definition section of part. So I will ask this question now. In the event this issue doesn't come up in the future. What protections are in place to ensure that if a government action is taken under these provisions, essential ferry services and highway transportation continuity are maintained without disruption to the public?
Could you please clarify how your question relates to Clause 13?
Well, yes, I can clarify that.
Recognizing the member.
So this particular clause talks about including provincial undertakings. It talks about including BC ferries. So now my question talks about what sort of independence and control BC ferries is going to still maintain, and how their operations might be affected. So what sort of continuity will be maintained into the future as a result of now being included in this definition?
Recognizing the minister.
Thanks, Chair. So there's no impact on any of that. Again, this is a definition, and in the context of how this is applied, it's necessary for it to be broad and inclusive.
Recognizing the member for Richmond Queensborough.
Earlier, the Attorney General mentioned that the intent was to address like traffic that's going on its way to Alaska from the United States. How come there wasn't any sort of reference to that in this definition? The provincial undertakings will be included only to the extent that involves trade between Alaska and the southern states.
Recognizing the minister.
Again, as I explained, is that the definition is meant to be broad, but then the regulatory power that's in Clause 18 is where you would have the ability to have very targeted regulation power to make sure it's hitting the right area.
Recognizing the member for Richmond Queensborough.
Has the government conducted a fiscal impact assessment of the potential financial exposure created by including ferries and ferry terminals under the definition of a provincial undertaking?
Recognizing the minister.
So no, because this is an enabling piece of legislation, so there's nothing there to do an analysis about. This just enables government through other clauses, not the definition. The definition has no enabling power or ability, but for cabinet to make put such a regime in place.
Recognizing the member for Richmond Queensborough.
Does the Attorney General's Department foresee future fiscal impact assessments being done, although that this is an enabling piece of legislation?
Recognizing the minister.
Thank you. So again, enabling piece of legislation, so the time that would happen, and it would be important to do that, so the minister or cabinet would do that, is to understand the fiscal impact of whatever that measure is going to be.
Recognizing the member for Richmond Queensborough.
Can the Attorney General explain how allowing government intervention in ferries, ferry terminals, and highways is proportionate and connected to the stated goal of responding to international tariff disputes
Could you please,
involving the U.S.?
member, could you please clarify how the question relates to Clause 13?
Well, the clause does talk about the provincial undertaking, does talk about ferries last time I checked, and talks about the Transportation Act, talks about the Coastal Ferry Act, and just the subheading right above it talks about tolls, fees, and charges. The Attorney General explained that this applies to the U.S., explained that it applies to the trade corridor between Alaska and the southern United States. I think my question addressed every single one of those points.
Recognizing the minister.
Thanks. So again, nothing in this definition talks about taking over the governance or authority of ferries or coastal ferries. So that's just not part of this piece of legislation, nor any of the enabling powers that are in place.
Recognizing the member for Richmond Queensborough.
Going back to clause 13, talks about provincial undertakings, talks about ferries, talks about Transportation Act, talks about Coastal Ferry Act, underneath the title tolls, fees, and charges. So the next question has to do, we were explained about Alaska earlier, and that Alaska example is not in this particular definition, so we can't see it. But other than the Alaska example, what specific threat or risk is the government responding to by including these definitions in clause 13?
Recognizing the minister.
So this definition of provincial undertaking is drafted purposefully broad. And that is because as it's applied in the further clauses that we'll get to, it's to make sure that the tools are there to do the assessment if we do ever need, and hopefully we never do, to need to have better tools to escalate a response against in the context of an escalating trade war.
Recognizing the member for Richmond Queensborough.
In regards to the broad definition that the Attorney General just mentioned, has there been any concerns from any stakeholders about this broad definition?
Recognizing the minister.
I have not heard anything about clause 3 or concerns about that, the definition.
Recognizing the member for Richmond Queensborough.
So, going on to my next question. So, going to the interpretation of this section, it talks about provincial undertaking. In law, undertaking has some significant meanings. So, and we have heard in terms of interpretation, we've gone through ordinary meaning, we've gone through legal meaning, and we've gone through there could be illegal legislative consequences of certain particular wording. So going to provincial undertaking, can the Attorney General please elaborate on why these specific words were used? I assume that provincial undertaking has been used in another statute, as in the Transportation Act, but other than that, why was this particular wording used?
Recognizing the minister.
Yeah, I thank you. I have answered this already. Provincial undertaking is taken to borrow from definitions both in Transportation Act and the Coastal Ferry Act.
Recognizing the member for Richmond Queensborough.
In the wording of this particular clause, it talks about provincial undertaking, but then it goes further and then it refers to provincial public undertaking. Is there a reason why the definition becomes a 3-letter word rather than a 2-letter word in clause A?
Recognizing the minister.
Thank you. So provincial public undertaking is defined in the Transportation Act, and that's why it's got all 3 words in it. Just to take back the construction of this definition, it's provincial undertaking means the following. So it actually defines it by the 3 subsections there, and that means it's calling upon each of those things to define what public undertaking means.
So that particular, thank you for that interpretation, explanation for the 3 words that states provincial public undertaking. The word public just kind of brings another question. Other than a public undertaking, could this include any sort of partnership undertaking, You see mutually, there's contracts are done to like build certain infrastructure and all that. There could be like a potential private undertaking that has some sort of regulation from the government. So other than public undertaking, is that pretty much exhaustive?
Recognizing the Attorney General.
Thank you, Chair. So if we can have some clarification, do you mean is provincial undertaking? So that definition that's in this, or are you talking about provincial public undertaking and whether it's an exhaustive list?
Recognizing the member for Richmond Queensborough.
So I guess that's why we need interpretation here, because there's a little bit of ambiguity in questions and answers here. So this talks about provincial undertaking, and then it like goes in and it says this is what provincial undertaking means. So that seems to suggest that it's an exhaustive list, which only provincial undertaking only means provincial public undertaking under Transportation Act, ferry under Coastal Ferry Act, and ferry terminals under the Coastal Ferry Act. And there can be no other meanings other than that. So would the Attorney General agree with me? This is an exhaustive list of what could be included in a public undertaking, or provincial undertaking, sorry.
Recognizing the Attorney General.
Thank you, Chair. Yes, it is an exhaustive list.
Earlier, the Attorney General mentioned that ferry terminals, or ferry, yes, the ownership of ferry terminals is owned by the province. It's owned by the provincial government. So why a need to include that under provincial undertaking when the province already has control over it?
Recognizing the Attorney General.
Just to be clear of what it was included in that definition of provincial undertaking.
Clause 13 pass.
Aye.
So ordered. We're on Clause 14. Shall Clause 14, recognizing the member for Kelowna Mission.
Thank you very much, Mr. Chair. As it relates to this section, we saw fairly extensive public commentary that telegraphed the intentions of government around how these particular clauses might be used, particularly with regard to goods movement to Alaska and other similar issues. Can the Attorney General expand on whether that was an intentional disclosure, intentional strategy, or whether that was unintentional?
So in terms of the construction of this particular clause, it sets out a regulatory regime where you could put into place tolls, fees or charges in response to the tariff threat. I think the member was asking about how the Premier has talked about this and publicly. So although he's not here to speak for himself, what I will say is that I think that in the context of that public discussion about how we were positioning ourselves to be a viable threat to the states, that if they were going to escalate, and if we remember back at that time where the executive orders were coming quickly, it was to get the attention of, and I think he talked about this publicly too, to get the attention of the Alaskan governor and our friends on the other side of the border to the south, to say that, we're serious, that if you don't talk to the president and help him understand how integrated we are and how we rely on each other for trade and for prosperity and for the well-being of our citizens, then we'll escalate.
Thank you, Mr. Chair, and thank you to the Attorney General for the explanation. Just going back to the public communication, the structuring of the bill, the design of the bill, could the Attorney General illuminate whether the application of the bill or the prospective application of the bill for the purposes she previously mentioned, did those purposes drive the development of this section of the bill, or was the bill developed and then that potential purpose identified?
Yeah, the bill was developed in response to the tariff threat, and I think what you saw when the Premier stepped forward and said, we will use the tools that we have to retaliate, you saw political responses from all sides of the border, and Congress is finally stepping up to launch lawsuits against the executive order power of the president. So I think we've seen more of a political response and retaliation, because you've seen governors on probably all sides or at the state level actually see, right, like what the implications of this trade war could be for their people and stand up. And that was part of a strategy in a trade war, right, is to figure out what tools you have to get the attention of the opposing member of the trade war.
Thank you very much. I certainly appreciate that explanation, and I think it is a solid explanation. I want to just restate my question to make it clearer, because I was attempting to ask a slightly more detailed question. So when I referred to whether the section of the bill was developed before the strategy, or the strategy was developed and the section of the bill was backfilled to make it possible, I'm not referring broadly to the ability to threaten retaliation or to get attention. I'm referring specifically to the potential functionality of the bill in imposing tolls on trucking.
Yes, so I can provide some further clarity. This bill was designed as our economic stabilization and tariff response bill. So yes, it was. It's to give the tools if necessary. So it's more than just words. It's got the legal backing behind it for us to be able to do it if necessary, to be able to hopefully never, but implement those.
Recognizing the member of the mission.
Thank you very much, Mr. Chair. And again, appreciate the explanation and the confirmation. That helps me to understand the process by which this was developed. At such time as those conversations were underway in the development of the bill and the development of the toolkit enabled by the bill, could the Attorney General illuminate for us what conversations and considerations there were around the potential of corresponding retaliation from Alaska, and in particular the use of the Passenger Vessel Services Act as a retaliatory mechanism?
Yeah, thank you. I think the member is raising one of the difficulties of us being in a trade war that we didn't ask for. which is that as a Team Canada approach, it was decided, and I think effectively as team members, is that we would show a strong pushback. So as you know, the federal government put into effect retaliatory tariffs, and we as a province, along with other provinces, designed, I think you've heard other responses of other premiers about what their retaliatory response could be. And I think the member is correct. Every time you step into the fact that you put into effect a retaliatory measure, there will likely or possibly be a response to that, right? So it's why the bill is designed in a way to have the maximum flexibility possible. So you can imagine a scenario where you could turn something on and off quickly, or you could be very precise about where it's put into place. And for how long. And that way we can make sure that we're proportional to any of the responses that we want to retaliate to, but also put in the thinking behind how to put in that measure to minimize impacts, but also understand what the retaliatory measure could be. I think another thing to keep in mind is that all of this is not without context. So there are conversations happening, right, in the context of all of this. Like, I think you've probably followed that the premier's a meeting with governors, right, and talking about the responses and what our position is. So it's in the context of there being a viable threat of us being able to put this, if we have to. It actually also helps with the conversations that you can have at the table with people to try to resolve the dispute.
Recognize on a mission.
Thank you, Mr. Chair. And appreciate that explanation very much. So just returning to the PVSA piece, obviously during COVID, we had a precedent that was established around the PVSA, around the desire and willingness of leaders in Alaska to see at that time temporary changes to the PVSA. And I think it would be an uncontroversial and fair statement to say that the government was perhaps surprised by the speed with which changes were made to allow cruise tourism to bypass British Columbia destinations. Again, just taking into account the significance of this particular mechanism, can the Attorney General illuminate for us what lessons were learned from that prior change around the PVSA during COVID that helped to inform the strategy around using this particular retaliatory tool or making it available?
Yeah, thank you. So yeah, that was a really difficult time, right, for a lot of people during COVID for many reasons, but that the cruise ships and getting them back and the impacts in Victoria, I remember that very well. And I think there would be lessons related to that about how we work together and how interrelated we are when it comes to our industry. But I think the interesting thing that we've seen is that as the trade war escalates, or when the president pauses things and then reassesses, every time somebody pulls a string on something, we realize how connected we are, right? And then they think, oh, wait, if I do this, then it's going to affect my industry too, right? It's going to affect the cruise ships that actually want to do business with British Columbians, and they get a benefit from that. So it was a part, I think this whole discussion has been a part of illuminating how interconnected we are. So as Canadians, we want to figure out how to, move on from this and not be in this battle but the response again is, but if we are going to be in this battle, we're going to show you that we're willing to also fight back. So striking that balance is so important. And I think we did learn from how integrated we are. We always learn that. We've been learning it even now about when we talk about the film industry and potential tariffs. And that's part of the issue with this trade war, is how do you respond in a way that shows your force and also protects industries as much as you can.
Thank you very much, Mr. Chair, and again, appreciate that answer. Certainly some very good points made there. So as the critic for jobs, economic development, and innovation, I approach this particular piece through the lens of concern around the long-term prospects of our cruise tourism industry. And one of the challenges that is there is simply around proportionality, in that there has been an argument advanced by the Alaskans that, as we've heard from other American authorities, we don't need you. There is about a $3 billion economic impact to the cruise tourism sector, accruing primarily to Vancouver, Victoria, and to a lesser extent Prince Rupert. And I will just say there's fantastic opportunity, upside opportunity in Prince Rupert around cruise. In evaluating the choice to use this particular mechanism with the reasonable assumption that the potential second-order retaliation could likely be around the PVSA and cruise, did the ministry or did the government more broadly analyze the potential risk to long-term disruption of that cruise relationship, where, in speaking with folks in the cruise tourism sector, different cruise destinations have different, let's call it, intrinsic draw versus having a draw that is a function of avoiding a fee, which is really the origin story to some extent of how we've been able to build such a successful cruise tourism sector, because the incentive structure exists, but it is a very old incentive structure that could very easily, particularly in a fraught moment like this, be changed fundamentally in a way that might create really significant downside exposure for our tourism sector. So I'm just wondering if the Attorney General can illuminate a little more of the conversation that happened around the risk-reward equation on using this particular retaliatory mechanism and on the risk of long-term destabilization of our cruise tourism sector.
The Attorney General.
Yeah, so I fully expect, and I know this would be true, is that before any measure was put in here, the type of analysis that the member's asking for would happen. And I just want to say I also understand the uncertainty out there and the fear that's out there. I just want to name that because, we all meet with people that are really worried about the uncertainty and instability in the time that we're in. And as a government, and I know probably everybody in this room, no matter what party you're in, our hope is that it doesn't escalate. Our hope is that we're able to get a version of an agreement with the states, and that we can stabilize for everybody, because we want the cruise industry to be, we know that the benefits it has, we want the jobs and the economic stability of having a stable trading partner or a diversification of trade. So just to say that our goal will always be that, and we also will have tools to get their attention if we need to.
Recognize Kelowna Mission.
Thank you very much, and I certainly firstly appreciate the response. I think it's very thoughtful. I recognize that embedded in the response is a theme that has come back repeatedly, and I think it's a legitimate point made that there are considerations that will duly be analyzed in greater depth at such time as directions are issued, and that has been I think an ongoing theme of the Attorney General's answers. I'm hoping that I can get a little bit more detail on the analysis that was undertaken at such time as this was included in the bill, and I say that I ask that specifically because the idea of escalation with Alaska, the idea of imposing costs on Alaska that could reasonably be assumed to trigger a potential retaliation, leveraging the PVSA as a tool, leveraging cruise tourism as the retaliation, that could reasonably be understood to be the intent. Anybody reading this bill, anybody listening to the Premier's comments could reasonably assume that that was a directive that was actively being contemplated. And as such, anybody who is a counterparty to that particular escalation, specifically Alaska, would indubitably be very aware that we were signaling that that was a tool in a toolkit. And taking into account the experience during COVID, extensive legal work, extensive public affairs work, extensive debate, extensive political mobilization happened out of Alaska around the PVSA, creating in some ways an adversary with a finger on the trigger, potentially, with a toolkit of their own available that could very quickly be escalatory, that could very quickly have very significant implications. So I just want to better understand. The Attorney General has answered that at such time as a directive was issued, there would be a greater degree of analysis undertaken around the potential economic consequences. Was that not undertaken before this potential escalation was very loudly telegraphed in the bill and in the media by the Premier?
The Attorney General.
Yeah, thank you. So I won't repeat myself. The full analysis will be done at the time of. And I just want to say that I think the Premier and the discussions that we've had are not just about legislation and enabling the tools to do it. It's also about the political pressure that we wanted to apply to get the attention. I mean, I think there are arguments you could make that the Team Canada approach, where we showed what we could do in every regional way, right? Like, I think you had Premier Ford talking about electricity. So then all of a sudden, all the neighboring states were thinking about, hey, we're really integrated with Ontario. And I think our version of that was talking about the transport that goes through one side to the other, like to connect the states to the southern states to Alaska, and that got attention, right? Which to show how integrated we are. So I do think this approach of saying, of highlighting this has led to like political discussions that are important. This bill will give the enabling tools that we hope we never have to use to be able to actually implement something like that. There's versions of this uncertainty and trade war that we're in where things escalate, and there's versions where they don't. And we need to be tooled up either way, and this helps us do that.
Recognizing the Kelowna mission.
Thank you. Very much appreciated. I think I respectfully didn't hear an answer around analysis undertaken around the potential consequences of this kind of escalation and potential impacts on cruise tourism. I will ask a different question, recognizing I may not get an answer on that one, but taking into account that the ministry, the government set out to put this escalation into the toolkit, and as such was taking on risk, was taking on the risk that there could be a significant escalation that could have significant downside consequences for a significant $3 billion industry. What, if any, efforts were undertaken or were directed to be undertaken in terms of mitigating that risk to our cruise tourism sector? And when I say that, I mean not only understanding the potential implications of a change to the PVSA, not only trying to manage that potential, but also proactively mitigating our dependence on the PVSA as the enabling instrument that is fundamental to the existence of a significant portion of our cruise tourism sector. So, for example, were efforts made or funding made available or directions given in order to make sure that there was greater investment or greater effort put towards strengthening the fundamental appeal of our cruise tourism destinations. So certainly an issue that was canvassed fairly extensively in tourism estimates was the implications of urban street disorder on affecting the fundamental appeal of our of areas like Vancouver and Victoria as cruise tourism destinations. So taking into account that the government was gambling or planning to gamble quite substantially on using leverage with Alaska that created risk exposure for our cruise tourism sector with $3 billion on the line, or some portion of $3 billion on the line, what plan, what mitigation, what strategy was put in place to make sure that if in fact that button was pushed, that escalation happened, we were mitigating the downside risk to our tourism sector as much as was as possible given the circumstances.
Thank you. I think the member is asking a pretty detailed and deep question that is about a policy area that isn't directly tied to this, but I'm happy to ask. I think Jedi probably could be the best to respond, and as he's the critic for Jedi, I think it's a good question. I think that there's a lot of work going on. I think there's a few parts of the question about diversification of an industry. So there's a lot of work going on about getting proper tools out to get an industry to do that. And again, with the risk analysis or the detailed analysis, I know that Jedi's working hard on, actually it could also be tax that are working, the ministry there that's working on how tourism impacts and how they're being mitigated as a result of the trade war that we're in. So these are all, that's why the proper time to actually understand and do that analysis is, so if this was ever to be, hopefully never, but ever to be a power that we feel we needed to use, the appropriate ministers would come before cabinet and show the discussion, and a lot of the questions would be probably very similar to what the member's asking about the fiscal and economic impacts of that. How are you protecting the tourism industry? What are the other sides? So before you even think about enacting something like this, you got to think about the consequences of it.
Members, take a short 10-minute recess. We'll return at 7:16 p.m. Order, we are on Clause 14. Shall Clause 14 pass? Recognizing the member for Langley Abbotsford.
Thank you, Speaker. I've spoken to a lot of truckers regarding this, and it's a huge concern that they have. It suggests it applies to trucking, so why is this government bringing in a bill that could potentially add more costs, red tape, uncertainty, and there's no service guaranteed to truckers to make things better for them? What I've been hearing a lot from truckers is they're always last on the list, last to get paid, last to be consulted. And right here, the wording of this actually suggests that there could be a lot of implications for truckers, but they're getting no infrastructure, no improvements to infrastructure. What is the money that tolls, fees, and charges going to be used for? Truckers want to know, will it improve their infrastructure, the routes, the turnaround times? I think this is a very valid question from truckers because it's really tough right now with this economy, getting things going, and they have a lot of concerns. I just really want some clarification on this.
Recognizing the Attorney General.
Thanks, Chair. So, I'll leave it to the Minister of Transport, which I'm sure he would, to go through all of the investments and the ways we've made trucking easier in this province, and we'll leave that to him to go through, because just a few things come to mind about infrastructure investments that have been pretty key to truckers. But that aside, this bill doesn't earmark where the tolls and fees collected would go specifically, but what it does is give powers under Clause 18.
I'd ask that the members in the gallery please keep their voices down. Thank you. Attorney General.
Okay, thank you. They were talking about tolls and charges and the tariff war over there, I'm sure. So the what was I talking about? So basically the clause 18 actually allows there to be a benefit. Like you could see the minister and the cabinet designing a particular regulation that tries to help the local trucking industry in a way that they're being harmed by the tariffs or something that's happening related to tariffs. Like I know one of the things we've been hearing is the imports are being affected and ports are being affected. So I think it also gives the opposite potential, right? That you could figure out how to design a system for your regulation to target and to protect BC truckers and BC industry, and design it in a way that if you're retaliating and maximizes harm to the people that you want it to harm.
Thank you, Speaker. The reason why I ask about this is there's been a lot of previous government policies, being a trucker and knowing a lot of truckers, when the carbon tax was implemented. For example, I can tell you that there was no nothing, no check bounds or anything for truckers. There was nothing in legislation that would say, if you're paying this, you have to pay it forward. Even in union rates, I work for a union. My actual union rate, when that was implemented, we had a pause on our fees. So truckers are continuously asking me, where is the benefit for us in this? It seems to be every single time they give. Even when the DPF emissions reduction for the fumes was brought in, there was an added cost, but there was nothing to protect them from losing revenue over it. My question is, when you're doing this, how many truckers did you consult? How many individual owner-operators? How many people from the construction industry? Not just the big carriers, your top 5 ones that get all the jobs, but the smaller ones too. The backbone of BC, the one-off, the mom-and-pop shop type businesses that keep this province running. It seems to be a lot of policy gets put on with all the mega corporations, but we're forgetting a lot of these individual one-offs actually combine to be almost around the equivalent workforce. I don't think we should be leaving them behind, and that's why I want to have some clarification on this.
Thank you, Chair. So we're not leaving anybody behind. In fact, we are solidly standing on the side of British Columbians, every British Columbian, big or small businesses across the province. So nothing in this bill would indicate otherwise. What I would say is that the Minister of Transportation is in contact with many different organizations, big or small, trucker associations, understanding what the needs of all their industries, just like any minister with stakeholders is responsible to do. So if there ever was the need, and hopefully there never will be, the need to enact some kind of retaliatory measure through this Part 3 of the legislation, then of course the minister responsible would be speaking with those that may be impacted. They'd be designing a mechanism to make sure they were protected and supported through this, and they would be figuring out which tools are the most appropriate ones to help people through. The whole point of this bill is to support people through a trade war, and so all the tools in here could be mobilized to do that.
Seeing no further questions, recognizing the member for Richmond Queensborough.
I have a few questions, actually. All right. We've heard a lot about this particular part of Bill 7, Clause 14, being an enabling piece of legislation. But obviously there was some sort of brainstorming that went behind it, and this piece of legislation was brought up. And there might have been some sort of consulting, there might have been some sort of framework to why this was being brought forward. So I want to ask, and then obviously when you're talking about tolls, fees, and charges, you're talking about another source of revenue. And so this next question comes up. What estimates, if any, does the government have for revenue versus cost? And did those inform this decision to actually seek this power? So basically, you enable this legislation, it might collect some revenue, right? But as a result of collecting the revenue, what would be the cost in order to collect that revenue? What would be the cost?
Yeah, so again, this is an enabling piece with no actual regulation in place to analyze. So I'll go back to what I've said a few times now, which is the time that analysis would happen would be at the time where it's contemplated, if we ever get to that stage, that regulation should be put in place.
So is it the government's perspective the government would not really care about the revenue? At this stage, they're not worried about the revenue that they would actually get under tolls, fees, and charges.
The goal of this measure is not revenue or revenue generating. The goal is to be a retaliatory measure against if we are in an escalating trade war.
Member for Richmond, Queensborough.
If the goal is to retaliate and the tolls do get put down, there will be some revenue, correct?
Yeah, I mean, it would depend on the measure, the length of time, all those things, but yes.
Recognizing the member for Richmond, Queensborough.
The Attorney General has referred to a specific reason or a specific specific trade route to address in terms of this particular clause, and that was Alaska and the route between Alaska and the southern United States to our south here. So in regards to that, I understand that Alaska's in the picture and we have the southern United States in the picture, but after considering that, does the government have a potential list of potential locations where these tolls may be located in the future? Alaska is being mentioned.
The Attorney General.
No.
Recognizing the member.
And, okay, so now just to change the line of questioning here a little bit, obviously there's individuals that could be facing the tolls and they would be having to pay those tolls. And individuals that come to mind, there could be United States citizens, foreign nationals, there could be permanent residents from Canada, there could be British Columbians. So in regards to this particular legislation, is there anything here, I don't see anything in this clause 14 that distinguishes between foreign nationals, American permanent residents versus Canadian permanent residents. I don't see it. I understand it's enabling legislation, but it is pretty broad, and a minister that takes this up, and there's no limits to what the minister can do with this. So is there any sort of distinction here? I don't see it in this particular clause, but is there something to safeguard that it doesn't get applied to British Columbians?
Recognizing the Attorney General.
Thank you, Chair. So as we get to Clause 18, we can talk about the regulatory making power that the Cabinet and the Minister present that in order to do that. The whole intent of it is to respond to a tariff threat, and the powers that are put into particularly Clause 18 allow that ability to design it precisely for what's intended.
Recognizing the member for Richmond, Queensborough.
I get that this particular clause was made quite broad, and there's only 2 paragraphs in it. But is there a reason why you couldn't just say, well, this will only apply to U.S. Residents, this will only apply to U.S. trade coming in or U.S. transport coming in. It will not apply to British Columbians. It will not apply to Canadian citizens. It will not apply to British Columbian permanent residents. If that would actually alleviate a lot of concern that British Columbians have about this legislation if there was just an exception carved out for that. So going back to the question, I don't see it in this legislation. What's the reason why you can just add that extra provision in here?
Okay, thanks. So there's many reasons why the construction is the way it is. The first one is the way that this is designed is a precedent of that's commonly used by government when it's talking about enacting, it's putting provisions in legislation related to enacting fees or charges. So the construction is consistent and stable amongst statutes. The reason that it's important to be flexible on the outset, and it's designed this way, is because if in regulation or in legislation, you clearly signal what might be in effect a loophole to paying that fee or tax or toll, by expressly saying certain things are true or not true within the enabling power, then you've created the potential for people to design their affairs from the outset in a way that creates their ability in a stagnant way, right? Because legislation is not as movable as regulation. So what you've done is in a very stagnant way, created a way for people to get around through loopholes of what tolls, fees, or charges in this case might apply to them or not. So generally, the wording of these kind of provisions is left broad and vague, and the way you change it is through regulation. Because through regulation, you're able to adapt and adjust and to mitigate at any loopholes that may be created for people to avoid in a more automatic way. I think that there's examples we were talking through about how in an escalating trade war, it might actually be, it might show up in different ways. So another reason for flexibility is it might be that you want to design your regulation to target American cargo that's in a BC truck. So you might actually have you might have to actually be more nuanced related to what is the nationality of the thing that you're attaching a fee to. But the real thing is like, just to clarify, the way that this is designed legally is to attach a fee to the thing. So it's attaching it to the public infrastructure, right? So it's attaching it to the road or to the ferry or to whatever, and the fee is charged by usage of that. But you'd be able to design according to this, the powers in here, the ability to put a regulatory regime around that, so you can understand how you're going to apply that and who it's going to apply to and what classes of persons, and Clause 18 talks about that.
See.
Thank you very much, Mr. Chair. Appreciate that explanation. I'm just looking to, again, understand a little bit more about the diligence undertaken around the implications of these particular changes, especially given the extent to which government signaled to the marketplace, both domestically and internationally, as well as signaling to stakeholders the type of approach that might be undertaken. I think we've more than adequately canvassed the piece around tourism, but I do want to understand what work was undertaken around trucking and goods movement, and in particular, I would love to better understand what level of detail government dug into in terms of understanding what a probable market response would be from individual trucking companies. So, for example, did they look at what the elasticity would be in terms of different toll rates and different reactions in the marketplace? If, for example, a toll hit a certain threshold, would there be an expectation that you might see trucking companies begin cross-docking between different trucks that were differently plated, things of that nature? So was that analysis undertaken in order to understand what a probable market response would be to different toll or fee structures at different rates?
Yeah, so this is in the same thing that I mentioned last time. The time to do that would be at the time of proposing or understanding what the regulation is and where you want to put it.
Thank you. I'm somewhat prepared to accept that explanation as it relates to the broad range of potential procurement directives that could be forthcoming but are not yet known. I'm really struggling a little bit with the fact that emerging from this specific section, there were very, very specific potential directives that were very publicly signaled by government, by the Premier. And as it relates to whether it be the cruise tourism implications or whether it be on this piece, I think it's just really important to recognize that a directive does not need to be issued in order to start having an effect in the marketplace. A direction that is signaled as a potentiality is very likely to elicit a reaction from stakeholders and market actors. And in this instance, I am assuming that it probably did. So in the case of counterparties in Alaska reacting, counterparties in Alaska do not start scenario mapping the full range of their potential responses the day that a directive is issued. If they're doing their jobs, they would presumably begin mapping the full range of their potential responses the day that that potential escalation is signaled or is predicted. By the same logic, any responsible operator in a transportation logistics business would, in all likelihood, see the prospect of tolling signaled, as it has been, quite loudly and quite clearly with a fairly significant degree of detail, and those actors in a marketplace, those stakeholders, begin reacting to that. They don't begin reacting to a procurement directive because they would be foolish to wait until something that has been signaled as a very real possibility or probability by government has been clearly outlined. So I am going to assume that both institutional stakeholders, organizations like the BC Trucking Association, United Truckers, large trucking companies, small trucking companies, other transportation logistic players and operators, individuals who operate cross-docking facilities that are border adjacent, individuals involved in all manner of different aspects of our transportation logistics system, in all likelihood, were motivated to go and start talking about what this would look like. That could lead to individuals making investment or disinvestment decisions in terms of physical infrastructure, gambling on the possibility that there could end up being a requirement for cross-docking.
Member?
Yes.
I just would politely ask if you could perhaps help me understand how your narrative is connected to Clause 14.
I would be happy to do so. And that is, again, because what I'm trying to elicit from the Attorney General, as I have attempted previously, is an understanding of what efforts were made, both to consult and to provide predictability in the marketplace, especially for BC companies, around the implications of what these policies would be. Because I reject the narrative that the market starts reacting or that stakeholders start reacting when a procurement directive is actually issued. And I would submit that the day that government began signaling that this was a prominent weapon in its arsenal of response would logically have been the day on which British Columbia companies, industry associations, institutional stakeholders began trying to understand what this would actually mean. So with that said, could the Attorney General please expand on how specifically stakeholders in the transportation, logistics, and trucking sectors were consulted around the potential implications specifically of this potential change and what advice was provided to them, what mitigation measures were identified for BC-based companies in order to reduce the uncertainty for them, in order to enable them to be better prepared to respond if such a measure was in fact brought forward. Because it strikes me that when you look at these procurement directives, you're not exactly operating with the element of surprise when you
Member,
telegraphed it this far out.
Again, I would ask that you please help me understand how your narrative right now is connected to Clause 14.
Yes, it's directly related to Clause 14 because the Attorney General has very specifically articulated on a number of occasions that Clause 14 was purpose-built in order to enable the kind of tolling structure that we're discussing right now. So this is expressly the purpose of 14 as expressly identified by the Attorney General, who has expressly told us that it was developed in order to enable this tool in the toolkit of response. So I don't think I could be any more closely aligned with the privately and publicly stated intention of the section, Mr. Chair. So again, I would just ask the Attorney General to again help us understand what efforts were undertaken to make sure that given the loud signal sent to the marketplace of transportation, logistics, and trucking players throughout British Columbia, what specific consultation and communication was undertaken in order to make sure that the BC-based Canadian businesses that we're trying to help through this overall bill were actually set up to be best able to respond to changes that government had signaled might be forthcoming.
Thank you, Chair. The Minister of Transportation has been in regular contact with the stakeholders related to this and the trade war in general, and that's the work that we expect all ministers to do. And I've answered already what the timing would be about the analysis.
I was earlier asking questions about why there was an exception carved out for British Columbians, British Columbian residents, Canadian citizens, and why wasn't that section just applicable, Clause 14 just applicable to the intended target, which is the U.S. residents, U.S. citizens, U.S. permanent residents. And I was told that there's there could be some loopholes, and there should be a prevention of loopholes, and also the exceptions can be dealt by regulation. But the problem with dealing with the exceptions by regulation is there's no legislative oversight. It would be done by cabinet. And there's a lot of concern, as we have heard already from a lot of people in the public about tolls, and they're thinking, well, there's tolls, fees, and charges. They're worried about it. And assurances alone cannot soothe their concerns because today there's significant financial hardship out in the general community. So many people are just $200 away from not making their ends meet. So just the talk of some tolls, it's very significant within British Columbia right now. And so I am of the opinion that there should be exception here for British Columbians, that will help soothe their concerns, that it will not apply to them. And so for that reason, I'm going to be introducing amendment to this particular clause. And what that amendment does is, so I'm moving amendment to Clause 14, and Clause 14 to be amended by adding another subsection, and that subsection will be subsection 3. And I'll pass over the proposed amendment. And I can speak to the amendment, or we, okay.
So, yeah, that's what I was suggesting. Recognizing the member for Richmond Queensborough, if you could
Okay.
provide additional comments or remarks, please go ahead.
Okay. So I'm moving an amendment to clause 14 to add a new subsection, and the subsection would be subsection 3. And subsection 3 would read as any regulation established by the Lieutenant Governor and Council may not, A, impose a cost, toll, fee, or charge upon British Columbians. B, impose a cost, toll, fee, or charge upon Canadians. C, C, impose a cost, toll, fee, charge upon permanent residents of Canada. There was a typo in that last one. Can I just amend the typo and hand it up?
Yes, we'll deal with it.
Okay.
So, the committee will now take a 10-minute recess. We'll return at 8:03 p.m. Calling the committee back to order. Members, we have an amendment to Clause 14. I will give the floor to the member for Richmond Queensborough. The amendment is in order.
All right, so we're dealing with clause 14 here, and I have moved a amendment to add a subsection 3, which states any regulation established by the Lieutenant Governor and Council may not impose a cost, toll, fee, or charge upon British Columbians. B, impose a cost, toll, fee, or charge on Canadians. C, impose a cost, toll, fee, or charge upon permanent residents of Canada. Through our lengthy debate today, I asked whether there was a distinction or exception put in to exclude British Columbians, and there clearly is not one in the actual wording of the legislation. So, I moved forward this particular amendment. The amendment would prevent Bill 7 being used to implement road pricing or highway tolls on Canadians. The government has said they will not implement road pricing. This amendment guarantees it. In the news, the government appears to be considering vehicle levies. This amendment would prevent the use of Bill 7 to bring in vehicle levies. The government would be required to bring in separate legislation through the legislature in the event that it wants to bring in vehicle levies. So this provides assurances to British Columbians that they will not be singled out and they will not have to face tolls. British Columbians are $200 away from being able to pay their bills in this province. The last thing they need is for our government to impose substantial new taxes through this legislation. We hope the government will be true to their word, support this amendment, and prevent this bill from bringing in tolls, fees, costs, and charges on British Columbians. So we feel that on this side of the House, we feel that this is a fair, proportioned amendment, and it protects British Columbians. And I urge every member of this House to support this particular amendment. Thank you.
The question is the amendment to Clause 14 shall, the Attorney General.
Thank you. I'd like to have an opportunity to speak to why I won't be supporting this amendment. The member talks about something that his amendments would prevent, which is that it would provide clarity to British Columbia and ensure that costs wouldn't be applied to them. And actually, in fact, the amendment as worded would do the exact opposite. And it's problematic for several reasons, and I'd like to take some time to lay out what those are. The first one is, generally speaking, regimes like this, where you're imposing charges, are done exactly in the approach that's contemplated in this bill, and that's for several reasons. So one, you have a standard empowering clause in order to charge a fee, and then you have a regulatory power in order to define it. I spoke at length as to why that's done earlier, to ensure that there's no ability to put loopholes or design regimes to avoid paying something when you rightly should be in the upfront part of the legislation. It's a standard approach that exists in Alberta, Ontario, Nova Scotia, and British Columbia. The construction of this clause is also problematic. It says at the very front, any regulation established by Lieutenant Governor and Council may not. That is very, very broad. To say any regulation established is much broader than the regulatory power that's provided under this section, and a huge scope that we wouldn't understand what the legal consequences of that would be as I'm standing here in front of you. The next part of this is the subsections use the word cost. The word cost is not used or applied in any part of the bill, so it lacks meaning or definition or understanding as to what that would mean. Along with, it's not clear. The member mentioned vehicles. Nowhere in here does it say vehicles. The definitions of British Columbians, Canadians, permanent residents, it could be very vague. You could have, in fact, just set up a regime through this amendment where it would be very easy to figure out a way to avoid paying a toll if you rightly should be paying it. For example, you could, it's vague to know if you could understand whether a BC driver was driving an American truck with a license plate, whether or not a fee would apply. There could be a whole number of scenarios that I could run through this amendment to show that it would actually create more confusion. So the right way to do this thing is to do it by regulation, exactly how the bill is set up to do. And just the final point that I want to make, which is actually another reason why it wouldn't make any sense to put this amendment in there, is that by listing certain exemptions, like you have in this, like the member has in this regulation for British Columbia's Canadian permanent residents, it causes a lot of problems for Clause 18, because Clause 18 is the regulatory making power. So it causes confusion as to why you would, how or why you'd be able to figure out which class of drivers or categories of drivers that the regulatory power could be attached to, by creating the confusion of exempting a very particular or listing particular ones here. The regime that we have here is the perfect balance between being able to respond quickly in the event that we do need to put into place something none of us hope we ever will have to, and also being able to adapt it and make it apply to minimize all impacts to British Columbians, and make sure that it's targeted at the right source. So for all those reasons, I won't be supporting this amendment.
Recognizing the House Leader of the third party.
Thank you, Mr. Chair. I will not be supporting this amendment, and for all of the reasons that are raised by the Attorney General, but I just want to amplify on one reason in particular, and that is that it has been made abundantly clear through all the readings so far, and through all the lengthy committee deliberations so far. Unequivocally, this legislation is tariff response legislation. It is the focus of this legislation is to be able to effectively respond in a timely way to trade action by the U.S. and in particular. And what we don't want to do is have a piece of legislation where advisors to the President of the United States say, have a look at this, Bill 7, it's just got passed. Isn't that interesting? Look, there's an exemption for British Columbians, Canadians, and permanent residents. I know how we can get around this. We can go around this tariff response. We'll just structure it so that we can totally avoid the effect of the regulations. Clause 18 provides a detailed regulatory framework with all the usual safeguards to be able to tailor our response, but not send the President of the United States a recipe on how to make our tariff response ineffective. And so for that reason, I will not be supporting this amendment.
Recognizing the member for Prince George Mackenzie.
Thank you, Mr. Chair. And I have to disagree with the previous speaker in the fact that the only thing that we're learning out of this section of this bill in its entirety is that this is a lightning rod for the President of the United States to actually be looking at this bill and look for retaliatory measures. We're making sure that we're protecting British Columbians from getting tolled and from having rope pricing or levies charged on them. And so this is about trying to protect them. Overall, we wouldn't need to be having this conversation if the government pulled Bill 7 its entirely. So I will be supporting this amendment in order to protect taxpayers.
The question is on the amendment to Clause 14. Shall the amendment pass?
Aye.
Opposed? Division's been called. Before I put the question, oh, that didn't work. It's on paper. Come. There you go. A gentle hand shall rule the land. Sword in the stone. Before putting the question, I remind all members that only the members of Section C or their duly appointed substitutes are authorized to vote. The question is the amendment on Clause 14, moved by the member for Richmond Queensborough. Those in favor, please rise or indicate otherwise. Thank you, members. Please be seated. Those voting nay, please rise or indicate otherwise. You may be seated. Clerk?
Those voting aye, Moz, McCall, Neufeld, Payton, Wilson, 5. Those voting nay, Sharma, Rutledge, Boyle, Lajeunesse, Brar, Higginson, Botterill, 7.
The motion is defeated. Recognizing the Attorney General.
Thank you, Chair. I move that the committee rise, report progress, and ask leave to sit again.
Where is everyone going? Members have heard the question. Those in favor? Aye. Those opposed? Motion's carried. We stand adjourned.